My lord, I'd like to mention item number 24. I'm legal aid counsel for the respondent number 2.
Item?
Item number 24. I have not received paper book.
Otherwise, the paper book is prepared.
I have already received nothing. I'm for the state.
Okay. Miss Jayadaji, non-legal aid counsel, appearing on behalf of
Respondent number 2.
the respondent number 2 is a victim.
Yes, is victim.
Victim submits that she has not yet received. She is yet to receive paper book, and as such, she is not paper book and pay for furnishing the same. Okay. Who is for the appellant? Okay.
My lord, I'm for the petitioner.
Mr.
M. Kambo.
Client counsel for the appellant is present. Is paid for by the client counsel for the respondent number 2. List this matter after 2 weeks.
Yes, sir.
Okay. In the meantime, the official furnish a copy of the paper book to the client counsel appearing on behalf of the respondent number 2. Okay. Okay.
Bless.
May I, Lordship?
Yes.
Lordship, I want to mention item 23.
Item
23.
2, 3.
Yes, Lordship.
Yes.
Here, this previous council they have this served NOC. So this is NOC from this council.
For the appellant.
Yes. Now,
Okay.
and we are referring for this FLN now, filing this Bakalar Nama. So
You have not yet filed Wakalat Nama?
yes, I will file now.
You're filing?
Yes.
Okay.
So,
Mr. You're Mr.
T Tamin.
Submit that they are recently been engaged to appear on behalf of the appellant and prays for some time to file a wakalatnama and also to prepare the case. The prayer is allowed. List this matter after 3 weeks. Okay.
Lordship, after 2 weeks.
2 weeks.
Yes.
Okay.
Much.
Okay.
May I please? I'd like to mention item number 10. The conducting counsel, is a Delhi resident. Due to some medical emergency,
For the petitioner?
yes. So kindly this matter may be fixed on 4th of December.
You have informed the
Yes.
respondent?
Yes.
Okay.
I'm for the state lawsuit.
Okay. Mr.
Yes.
Submits that the conducting counsel, Mr. Sering Gyatsa,
G-Ball.
Jeevan, is out of station. Okay. And he has a consent from the other side, and with the consent of the other side, prays for listing this matter after
On 4th of December.
or on. Okay. Which is, okay. Lakshmiha, Planet, additional PP has no objection. Prayer allowed. List this matter on 4th.
There is an interim, right?
Stop. Para. The interim order passed earlier shall continue till then. Okay.
Like to mention the unlisted criminal petition
This is regarding.
regarding modification of bail order. As well as
Unless, why unless tomorrow? Tomorrow.
Regarding bail matter.
Tomorrow, get listed tomorrow. Okay.
All right.
I'd like to mention item number 14 and 15.
This is in the order column. What?
I have taken consent from other parties. Respondent.
What do you want?
Next, adjourn next date.
Hmm?
May give next date. Your listing after
This
3
I is
weeks.
for, what is this I for?
My lord, there is an interim in. Also interim in this.
Wait for some time, we'll pass order, we'll grant
Mhm.
adjournment, wait for some time. Okay, we'll have to see.
Okay.
Okay.
Lordship, I beg mention item number 9. So I am for respondent on behalf of the arts owner. My leading counsel is out of the station for some urgent work, so he could not come able to today. So kindly adjourn the matter. And I also concern with opposition party. So adjournment might have
You're
on
for the
2 weeks.
petition, you're for
Yes.
the petitioner.
No, not petitioner, respondent.
I am
Yeah.
for the petitioner, my lord.
You're for the petitioner.
Yes.
You have no objection.
No objection.
Okay, Mr.
Arts owner,
No, you are
K. Tagar,
appearing on behalf of Mr. R. Sonar, Land Council for the respondent with the respondent. Praise for listing this matter after
after 2 weeks.
2 weeks, to which Mr.
M. Doji, my lord.
Land Council for the petitioner has no objection. They are allowed list this matter after 2 weeks. Okay,
My lord,
Mark
interim is there.
Douglas,
My lord, interim is there, my lord.
interim is there.
It may
Correct.
continue.
The interim order passed earlier shall continue till the next date. Okay.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 20 on behalf of Mr. O. Modi, leading counsel for the petitioner, Lordship. Lordship, this matter may be listed after 1 week, Lordship,
Why?
because
This is in the order.
Yes.
Let us see that. Wait for some time. We'll pass order, we'll adjourn, but let us see the order.
yes, Lordship. May I please, my lord?
Yes.
My lord, I beg to mention item number 21 and 22. We have taken the consent from the other 40. 21 and 22.
You are for?
For 21, I'm for the petitioner.
You're for the petitioner.
Yes, and for item number 22, I'm the respondent.
In 21, you are for the petitioner.
Petitioner,
22, you are for respondent.
respondent.
What do you want?
Adjournment, my lord.
Who is for the other side? Have you informed?
Yes, we have taken the consent.
For 22, I'm appearing, Your Lordship.
22, you are for
State of AP, Your Lordship.
state. Oh, it's analogous matter. 21 and 22?
Yes, my lord, we have taken the consent.
No, what I'm asking
22
is
is different, Your Lordship.
21 is different.
Yes.
Okay, first, right. 21, have you informed the other side?
Yes, my lord.
In 21, you are for the appellant.
Yes, I'm for the appellant.
Okay, you are Mr.
H. Takum.
H.
Takum.
Land counsel for the appellant with the consent of the other side. Praise for adjournment of the metaphor.
I'm on behalf of Opada.
Okay, how? When do you want?
4 weeks.
Why 4 weeks? Okay. 4 weeks. The prayer is allowed. List this matter after 4 weeks. Okay. Yeah, in the 22, you are for respondent.
Yes, my lord.
Okay. Same, huh? Mr. Land counsel for the respondent. Praise for listing this matter after 4 weeks, to which the land counsel for the appellant has no objection. Prayer allowed. List this matter after 4 weeks. Okay.
Deeply obliged, my lord.
May I approach your lordship?
Yes.
Your Honor, this is the case civil revision petition 4423 invoking the Article 227 of Constitution of India, read with 115 of CPC regarding legality, validity, and order of the Honorable order dated 18/5/2020 passed by the London District Judge and UPI regarding. May I look page number, Your Honor? 88, Annexure 11, Your Honor. My lord. This is the impugn order which already passed by the district and session judge on dated 18/5/2023 to starting the trial, which is already ex parte judgment already passed, the London district and session judge regarding after all the procedures without any single procedural lapse. Entire is very good and completed, Your Honor. This is the impugn order, and for this legality and challenging this impugn order, I filed that this civil revision petition, Your Honor, my lord. May I look into Annexure 1, page number 15. This is the order dated 22/7/19.
Just a
It's
minute, huh? Just
yes.
a minute. Huh? What is this? Page 89, just a minute. Okay. Legality.
And subsequently, page number 16,
So-
annexure.
Just a minute, 88 is a impugn order,
Yes,
page 88.
page 88, annexure 11.
Hmm?
Page
Page
8,
88,
annexure 11, man.
yes, annexure 11, 18/5/2023. This is impugn order.
Yes,
You are agreed by this?
yes, my
Agreed
lord.
by which one? Relevant portion? The petition was allowed.
Yes,
So what?
allowed. Regarding to starting the trial, to give a opportunity to file a reply and the examination, cross-examination and defense his case, Your Honor, in part of the respondent. So this already ex parte judgment already passed. They simply pleaded on issuing of the notice. They never served the copy of the notice, which is steps taken by the applicant herself. But I have a clear
The
proof.
order was passed by whom? The
The
earlier order?
earlier order, Your Honor, my lord, the ex parte judgment
Ex parte judgment was passed by?
by the district session judge, Your Honor. This is the page number 17, annexure 3.
Seventeen.
Page number 17, annexure 3, my lord.
This order was passed in review or what?
This
Page
order,
88.
page
impugn
88,
order.
the impugn order to give opportunity to respondent to defend his case, to restore the case, Your Honor, my lord.
Restore the
Restore. In simple, Your Honor, my lord. They
No.
allowed to give
Where
their
is-
defense.
where is- Was it dismissed?
No, not dismiss, but give opportunity, kind of dismiss, my lord. Because after that opportunity, they file their reply. Along with that, they file their drafting issues and documentations. Ex parte judgment already kind of set aside and give opportunity to him to file his reply and defend his case.
Where do we find that to give opportunity?
In this, in the last part, second last part, I have carefully perused the order passed during my learned predecessor for ins of justice. Petitioner is allowed in result the suit is allowed.
What was the prayer in the petition? Who is for the respondent? This is for, no, not first time. Where is the respondent? Who is for the respondent?
Yes,
Respondent
Your Honor.
already appeared earlier.
No, during the ex parte hearing, Your Honor.
No, here before this court.
Yes,
Respondent already appeared,
yes, already appeared.
not appearing today.
No, Your Honor. In the last occasion, last two occasions, his counsel is appeared, Nandi Kagu sir, and copy already served of the main petition along with the IA.
Notice was issued.
Regarding the IA already issued, but this case is the motion stage after the dispose of the IA of condolation of delay.
Okay. So in this case, no notice was issued.
No notice was issued. In the IA already everything completed.
It was listed earlier in the earlier occasion also,
Yes,
since July.
yes. Only on the hearing of the IA, my lord, to control the 3 to 4 days. And same is the allowed.
See, there is a limitation in the, on the revision. Where have you stated?
Yes,
that
my
it has,
in IA petition.
well, let us see the ground satisfying the court that it has exceeded the jurisdiction. If you're coming under 115, then it is with regards to the jurisdiction only.
For revision, your honor, my lord.
Hmm. It otherwise is jurisdiction. Have you served a copy to the respondent?
Yes, in the earlier 2 occasions,
Okay.
last 2 occasions, I already served the copy along with the IA copy. The respondent already accepted the same. If any confusion, your honor, my lord, give a notice to him for that. Give opportunity so he appear for the contest of the case.
Okay. Or Mr. Morik Bagda, learned legal aid counsel for the petitioner. Para. This is an application under Article 227 of the Constitution of India. Read with Section 115 of the Code of Civil Procedure, challenging the legality and validity of the order dated 18/5/2023, passed by the learned district judge UPR in IA within bracket civil bracket close number 32 stroke 2022 in TS within bracket D bracket close number 22 stroke 2019. Where is the impugn order?
Yes, my lord. Page number 88, annexure 11.
What was the prayer for this petition?
Yes, to set aside the order, your honor. Simply said, because after serve the copy of the notice along with the petition and the orders, the respondent intentionally not appear without give any reason, and simply say that I've never received
So
the same.
it proceeded ex parte.
Ex parte.
And then there is an ex parte, whether the evidence was adduced.
Already everything is completed under the
Okay.
ex parte judgment.
After
And-
that, it was allowed.
And page number 22, annexure 4, it's very clear that the postal
Whether the application was for restoration or for what? Application filed by the respondent.
kind of restoration, but they simply stated that setting aside and cause the ex parte judgment in their
Okay.
petition, your honor, my lord. Page number 26,
Okay.
Annexure 7 series. Their petitions clearly mentioned.
Issue notice. Returnable by 4 weeks. Call for the PCR. The petition will take steps upon the, how many respondents are there?
Only one, Your Honor.
Okay, so we have already served copy.
Yes, already the lending cargo already appeared as a respondent counsel
Hmm.
and copy already served as per record. I second time served, but directly I hand over, Your Honor, my lord may kindly allow that. I simply submitted
Okay,
to the counsel of the respondent.
Since Mr. P. Ra appeared and accepted, already accepted notice on behalf of the sole respondent. No formal notice need be issued.
Tirar is my associate, Your Honor.
Hmm?
Lending cargo is the main counsel of the respondent. Tirar is my associate, Your Honor. Tadar, Tirar.
No. P. Ra is appearing for the sole respondent.
No, this is a mistake of the writing, Your Honor. Tirar is the
Then
petitioner
what is-
counsel.
And cargo.
N cargo is a yeah.
Okay, and cargo.
N cargo.
Instead of P. Ra
N cargo.
and cargo. Already appeared and accepted notice on behalf of the sole respondent. No formal notice need be issued. This matter. You inform the sole respondent.
Sure.
Since they are not appearing.
Yes, yes. I personally
Okay.
informed the same. Next date.
Mhm. Just a minute. There is nothing on record that he has been furnished with a copy.
My lord, in IA it is reflected. This is a main case.
Okay. This was in the IA. That was in the IA.
That one is IA. On the
Okay.
same day, I filed.
However, Mr.
Hmm.
Bagra self-furnished extra copy of the petition.
Petition.
The land council for the respondent within 3 days.
Okay.
List this matter after. I said returnable by 3 weeks only then. It will be.
Copy sir.
Which
What
court? Which court? Impugn order was passed by which court?
District in Session Judge UPA.
UPI. Then 3 weeks only. Make it 3 weeks. List this matter after 3 weeks. Okay.
If possible.
Returnable.
Okay. Sure.
Returnable within 3 weeks.
Okay.
Okay. Yes.
May I please your lordship? I am appearing virtually for item number 2 and 3, your lordship.
Yes.
Your lordship, item number 2 and 3 both are 480 through 3 BNSS application, your lordship. Here, your lordship, both of the petitioners are behind the verb more than 87 days, your lordship. This one is a charge sheeted case, your lordship. And at item number 2, your lordship, the FIR is at page number 10, your lordship. Page number 10, your lordship.
Yes.
Yes. The allegation is that precisely I'm submitting before your lordship. The allegation is that, your lordship, 3 girls, your lordship, brought by the petitioners, both of the petitioners, to Tawang, your lordship, for prostitution, your lordship. And out of the 3 girls, your lordship, 1 is minor, your lordship. So, lordship, the case has been registered at Tawang Police Station, case 1424, under section 65(1), 143, 144 BNS, read with section 4 of the POCSO Act 2012, read with section 5 and 8 of Immoral Traffic Prevention Act 1956, Your Lordship. Now, Your Lordship, after the charge sheet has been laid down, Your Lordship, the charge sheet at page number 14, Your Lordship, at Annex 3, Your Lordship. The charge sheet has been laid down, Your Lordship, at page number 14, Your Lordship.
Fourteen.
Yes, Lordship.
1-4.
1-4, Your Lordship.
Yes, yes, yes.
Here, Your Lordship, charge sheet has been laid down under section 143(4), 144, subsection 1, 2 BNS, read with section 5(1)(8)(a) of Immoral Traffic Prevention Act and dated 23/9/2024, Your Lordship. The now section of POXO has been removed in charge sheet, Your Lordship. But, Your Lordship, after charge sheet has been laid down, Your Lordship, at paragraph number 8 of my petition, Your Lordship, that is page number 5, Your Lordship.
Yes.
It was registered as ZR POXO number 27/24, Your Lordship. Now here, Your Lordship,
Yes.
the learned court below, taking the cognizance, Your Lordship, of this case, Your Lordship, under section 65(1), 143/3, Your Lordship, and 4, 144(1)(2) of BNS 2023, read with section 5(1)(8)(a) of Immoral Traffic Prevention Act 1956 and 6 of the POXO Act, Your Lordship. Again, POXO has been added, Your Lordship. So, Your Lordship, I have implemented the mother of the minor girl, Your Lordship, as respondent number 2, Your Lordship. In both of the petition, Your Lordship,
Respondent number 2 is
is the mother of the minor girl.
mother of the minor. Okay.
Minor girl, Your Lordship. Out of 3 girls, 1 is minor, Your Lordship. The rest of the legal lordship, a major, Your Lordship. She is 15 years, Your Lordship. So mother have been implemented as respondent number 2, Your Lordship. 88, Your Lordship.
Okay.
I will take this.
Yes.
This is very initial stage lawsuit without a fit case for to not maintainable lawsuit.
They said the charge sheet submitted. Record
That's
is-
why lawsuit, charge sheet already submitted lawsuit, but the
Lawsuit.
item number 2 lawsuit, here lawsuit, they have not annexed the rejection order lawsuit.
What
As
order?
they have not annexed the rejection order from the session court lawsuit, this POXO, this special court, because as per their paragraph lawsuit, they have clearly lawsuit, they have stated that they have not annexed lawsuit. As per some, they have reason best known to them, they have
They
not
have not?
annexed. They have not annexed the rejection order by the session court below. They have already filed the bail petition before there also.
Okay.
With due
You filed
respect,
bail
Your
application?
Yes, Your Lordship. We have filed a bail application before the session, just Lordship, UPI, Your Lordship. Now that bail
UPI?
application has Yes.
No, no.
Bomdila
It
lawsuit.
cannot be filed.
so
It
Bomdila,
must have
Bomdila,
been at Bomdila.
Bomdila,
It was
Bomdila.
rejected.
My apology, Your Lordship.
When it was rejected?
It was on
When it
22.
was rejected?
It was rejected by stating that, Your Lordship, that one order is there at item number 3, Your Lordship. The rejection order is there, Your Lordship. One rejection order is there. And here, Your Lordship, we have applied for the certified copy, Your Lordship. That's yet to get, Your Lordship. At Your Lordship, at paragraph number.
The item number 3 lawsuit, as per the order, it is reflected that the rejection is the ground that this victim statement has not been recorded yet, the minor statement. On the that ground, the bail was rejected.
Victim.
Bail application.
Okay, this was.
In the item number 3 lawsuit,
This
they have
application
annexed.
was filed
lawsuit.
during the pendency of the during the investigation period.
Lawsuit already charged that lawsuit. The
After
GR
that-
case they have already lawsuit.
Then, oh, wait, where is the ground?
Lawsuit. Ground is in the lawsuit, page 25 lawsuit. May I lawsuit the paragraph
Yes, sir.
5 lawsuit. It is observed that the cognizance of offense under section 65(1), 143, 341, 144, 1 to NS 2023, read by section 518A of the Immoral Trafficking Prevention Act 1956 and section 6 of POCSO Act are taken against the accused persons, namely Mohammed Anan Ali. That is the accused number, petition number, item number 2 lawsuit, petitioner name, and Mohammed Acham Babu. This is item number 3 petitioner lawsuit. It is also observed from the record of the case that victims' girls are neighbor of the accused Mohammed Asatam Ahmad Babu, and one of the victim is a minor, and the event of releasing the accused person before examination of the victim, but there is every possibility of hampering and tampering of the witnesses. As such, it is found that this is not a fit case to release the accused person, namely Acham Ahmad Babu, on bail at this stage.
Now, your bail has been rejected
By-
on this
by-
ground.
Hi.
Yes,
Yes, Your
yes.
Lordship.
On
Now
the-
my, yes,
What is the new ground you have taken this time?
Your Lordship, that was before the Honorable Session Court, Your Lordship. Now I am
Yes.
before Your Lordship.
Recently only.
Yes, Your Lordship. Lordship, the thing is that in already length of detention, Your Lordship, 88 days behind the bar, Your Lordship. Already charge sheeted case, Your Lordship. Trial has, Your Lordship, started, Your Lordship. And Your Lordship, investigation has already been completed, Your Lordship. So at this step, my humble prayer, Your Lordship, to issue notice, Your Lordship, with due respect, Your Lordship, to respondent number 2, with due process of law, Your Lordship, and with due respect, call for the LCR, Your Lordship, at this stage.
No, no.
My,
What I'm asking
yes, Your Lordship.
is the learned court below,
Lordship.
session court,
Lordship.
special court has rejected your bail on the ground
Yes,
that
yes.
the accused is neighbor, and there is a possibility, every possibility of hampering,
Lordship.
tampering with the evidence.
Lordship.
And
Lordship.
so what is the new
Lord-
ground you have taken?
Your Lordship,
For release
the
of-
length of, if Your Lordship see the length of detention, Your Lordship, now 88 days, Your Lordship, and Your Lordship, if Your Lordship kindly find at paragraph number 5, Your Lordship, it was observed from the record of the case, the victim girls and neighbor. Now, Your Lordship, if Your Lordship, notice will be issued, Your Lordship, to respondent number 2, Your Lordship, it will be clear, Your Lordship, that whether any objection will be raised by that respondent number 2 or not, Your Lordship, at a time of event of releasing the petitioners on bail, Your Lordship. So at this stage, Your Lordship, my humble prayer, Your Lordship, that notice may be issued through registry or through concerned police station, Your PP, Your Lordship. So my humble prayer on that ground, Your Lordship.
Now, since the case has
It is
already been charge sheeted, submitted in the charge sheet, notice not
Charge
required
sheet,
to be
charge
issued to police station.
No, APP,
But then
Lordship, now,
the order of the court is clear. The order of the court is clear. Why it was
Lordship.
rejected?
Lordship, by one chance, Your Lordship, one opportunity may be given, Your Lordship, so that I can issue the notice, Your Lordship. One, with due respect, Your Lordship.
We'll see the record then.
Lordship, record Lordship, we have to see whether the victim statement had been recorded or not, Lordship. Otherwise,
No.
after some time, they may be filed again,
During the
Lordship.
trial, in the trial.
Lordship, its trial already begun, Lordship.
Okay.
So that's why, Lordship, the bail objection was, this bail was rejected because, Lordship, victim statement was not recorded,
So the court want that the victim's evidence would be recorded first.
Lordship.
Okay.
So
Your
the
Lordship, with the-
state, Lordship.
Hard miss.
G. Bora,
You are
Lordship.
miss.
G. Bora.
G. Bora. G. Bora. Line counsel for the petitioner. Sir, this is an application filed under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for grant of bail to the petitioner. Petitioner is the accused.
Yes, Lordship.
Lordship.
Petitioner is accused.
Petitioner is the accused.
Yes, Lordship. But bail application filed by his sister, Lordship, with affidavit in page 8, Lordship.
Where is the authorization?
Lordship, page 8.
Hmm? Authorization 8?
8, Lordship.
8?
8 is affidavit, Lordship. The bail applicant, Lordship.
Affidavit, whether she has been authorized by the person inside, the accused.
Lordship, authorization is not there, only affidavit there, Lordship.
I have submitted the authorization, Your Lordship.
It has to be endorsed by the jail authority.
But Your Lordship, in Bakalatnama, they have endorsed, Your Lordship.
The petitioner himself is the, sorry, the accused himself is the petitioner.
Lordship. An endorsement is on the Bakalatnama, Your Lordship.
Endorsement by sub-jail.
By
Okay.
Lordship.
For release of the accused. What is the name of the accused?
Here, Your Lordship, the Hanan Ali, Your Lordship, alias Raja, Your Lordship.
Rena Bora. Okay. Annan Ali,
Lordship.
alias Raja, who has been arrested. In connection with the Tabang PS case number 14/2024 under section 65 within bracket 1/143/144 of DNS 2023, read with section 4 of POCSO Act 2012, and read with section 5 and 8 of immoral traffic within bracket Prevention Act 1956. You have to write, arrested in connection with GR POCSO number 27/2024 arising out of PS case. Okay. Yeah. Issue notice, call for the trial court record, scan copy of the trial court record. Since Miss sorry, since Miss Lakshmi H. Lakshmi has accepted the appeared and accepted notice on behalf of this respondent number 1, no formal notice need be issued to the said respondent. So the petitioner shall take steps upon the respondent number 2 by a registered post with AD within 3 days. Within 3 days from today.
Lordship.
So list this matter after. How long it will take? Dodar of Bora, what this is Rangapara is Assam. How long it will take?
Your
When
Lordship,
do you want?
at 22nd November, if Your Lordship permits.
After 3 weeks. List this matter after 3 weeks. Okay.
A date may be
Criminal
fixed, kindly. A date, kindly
When do
date me.
you, when?
uh,
Records,
20.
can it come, records can be,
Lordship, yes, Lordship.
okay.
TCR
Then-
record.
Okay,
Scan
when do
copy
you,
of the TCR.
Hmm?
Scan copy of the TCR record.
can copy?
Yes, Lordship.
Then, when it can be fixed? 14.
Yes, after, they have already asked for the time after 3 weeks.
When do you want? You said,
20, can it be 22nd November, your lordship?
okay, 22nd, okay, 22nd.
1 second, Lordship. Lordship, I'll try, Lordship. Let's see.
Hmm. The next case, only the name will be changed, huh? Similar,
Need-
same, only the name of the accused. Name of the
Yes.
accused is Ahatacham Ahmed alias Babu. Okay.
Much obliged, lordship.
Lordship, same order, Lordship, 3.
Yes.
So now, obliged.
Yes.
Yes, Your Lordship. Here we are aggrieved by the non-bailable warrant of arrest having been issued by the Chief Judicial Magistrate at Teju, Your Lordship, which has been issued by the learned Chief Judicial Magistrate in blatant breach of the statutory provisions as well as the settled law declared by the Honorable Supreme Court of India. It is the case of Inder Mohan Goswami, which revolves around the entire petition, Your Lordship. Let me come to the impugn order first of all, Your Lordship.
Been order is it?
50, page number 50,
50.
50.
Yes.
50 annexus 6 is the order which issued by the learned CGM at Teju in GR case number 53/2024, corresponding to Teju PS case number 28/2024. And this case is still pending investigation, Your Lordship. Now, may I read out, Your Lordship?
So yes, the relevant portion, which one?
Para 6.
No.
Para 6. Para 6. After due consideration, it is seen that the allegation against the accused person is grave in nature and the offense is also heinous in nature. It is also seen that the accused is not cooperating and he has not been found in Teju, indicating that he is evading police arrest. This line may be marked, evading arrest, because this is the issue. Therefore, the prayer of the IO is accepted and it is found that the arrest and custodial interrogation of the accused is required in the present case. Issue non-bailable warrant of arrest against the accused Batan Sokri. The non-bailable warrant of arrest shall be endorsed to the superintendent of police.
What is wrong in it?
I'm coming to that, Your Lordship. In pursuant to this, Your Lordship, the next page, Annexure 7, is the form of the non-bailable warrant of arrest.
Okay.
Now, being aggrieved by this non-bailable warrant of arrest order, we have filed a criminal revision petition before the Learned District and Sessions Court at Teju, which has also been dismissed, Your Lordship. Which has also been dismissed by impugn order, Your Lordship. Impugn order 3/10/24. And the NBW was issued on 8/4/24. And my criminal revision petition was ultimately dismissed on 3/10/2024. Lordship,
8 April.
yes.
It was issued on 8 April.
Yes. 8th of April 2024.
Okay.
Now, one of the questions which is very relevant for the purpose of disposal of this petition is, Your Lordship, whether any criminal code during the course of investigation, I'm saying, has the authority to issue any kind of warrant of arrest. That is right. Normally, non-bailable warrant of arrest or any kind of warrant of the code is issued during the course of trial.
What is the offense involved?
Offense involved, the allegation is 304, Your Lordship. 304. That
Not
is
302.
Not 30. Culpable homicide not amounting to murder.
302.
304. yes.
4.
Register under 304.
4. Yes.
304.
It's a dead case.
Yes, Your Lordship.
Okay.
I'm
Why
covered.
304?
That is the discretion of the police authority. We don't know.
Okay. Police came into the conclusion.
No, police, the case is still under investigation. That is still under
No, that
investigation.
is why I'm asking. It's a dead case only. Police came into the conclusion that it is under 304,
304.
not 302.
No. Police registered under 304.
Before trial.
Your Lordship.
Before trial, it has come in, police came into
Before trial
conclusion
and
that it
before
is
trial.
304 only.
Initially, on receipt of the FIR, that was registered under 304. On receipt, immediately on receipt of the FIR, that was registered under 304.
But it is a murder case, death case.
It is a death case. Somebody has died.
How is it possible?
Somebody has died.
Somebody died.
Somebody has died.
Hmm.
So therefore 304 has been. We don't know what is the outcome of the case now. The
Okay.
case is still under investigation.
Okay.
Here we are
Still
not,
under investigation.
yes, Lord. Now here, the core issue is that whether any criminal court has any kind of authority or jurisdiction to issue any kind of warrant of arrest during the course of investigation. That was the issue which fell for consideration before the Honorable Supreme Court in the case of Dawood Ibrahim Kaskar. And the Supreme Court, Honorable Supreme Court, has, while referring to Section 155 of the CRPC, has generally held that, yes, in terms of Section 73 CRPC, in certain situations, the court has the authority to issue arrest warrant. The court has never said they're non-bailable because no form or no statutory provision says any kind of language. It doesn't use any kind of language as bailable or non-bailable. It simply says warrant of arrest. Warrant of arrest.
Okay.
So in the case of Dawood Ibrahim, the Honorable Supreme Court has said, yes, in terms of Section 73 CRPC and in the interest of justice, even during the course of investigation, warrant can be issued.
Okay.
Now, we have to trace out as to under which provision of law that warrant can be issued. That is Section 73 of the CRPC, prior to coming to force of the new act, new law, Your Lordship, 2020, the BNSS. Your Lordship. Now, Your Lordship may come to 73, Your Lordship. It is very relevant. Your Lordship. Section 73, it basically says, Your Lordship, a criminal court can issue a warrant of arrest.
Yes.
Under three different situations, Your Lordship. When the accused or when the person is an escaped convict, number one, escaped convict. Number two, he must be a proclaimed offender. And the third one is that the person must be accused of any non-bailable offense and he must be evading arrest. Evading arrest.
Arrest, okay.
The first part is not there.
Okay.
He's not an escaped convict. He's not convict.
Yes,
He's
yes.
not he has not been declared as a proclaimed offender in terms of 82 years.
So he comes under third.
He comes under third if at all. If at all.
Okay.
It says a person who is accused of a non-bailable offense and he has been evading arrest. That is very important.
Yes.
The second part is important. He must be evading arrest. He must be evading arrest. Under this situation, under these three situations, the court can issue arrest warrant. Warrant of arrest. That is what Section 73 basically speaks of. We are confined to subsection 1 only, so we are not going to the other subsections, Section 73.
Okay.
Now, here, why we are questioning the legality of the order passed by the learned CGM as well as the order passed by the Honorable Sessions Court. The entire case is governed by the law declared by the Honorable Supreme Court. It is needless to say in terms of 141, Article 141 of the Constitution of India, any law declared
Now,
by.
what according to you,
Yes.
the court should issue, supposing the person
Yes.
in the cognizable case, if the person is not in the station, he has gone to some other district, some other state. How to arrest? What is the mode? What is the procedure to arrest the person?
That is very important. That is the core issue here.
Yes.
Here, there is a lawyer. Chapter 6 provides, Chapter 6 of the CRPC, and 11 times CRPC, Lordship. CRPC. Chapter 6 of the CRPC provides about the process to compel appearance.
Right.
All those provisions may be invoked by the investigating officer.
Right.
Even otherwise, being the offense cognizable, if the investigating officer believes that the accused person is not cooperating with the investigation,
Yes.
there are certain, how do the court believe that? The court cannot believe blindly. He will have to show to the court that, yes, he had issued summons. In terms of 160 CRPC, if the person is supposed to be acquainted with the facts and circumstances of the case in terms of 160, not necessarily to an accused, it uses the expression person. Even in terms of 160 CRPC, someone can be issued Otherwise, if the very person who is required to attend the investigating officer is really accused of any offense, then in terms of section 41 CRPC, notice can be issued. Even otherwise, thereafter, section 41, which has been amended.
Case where the IO came to know during the investigation that the person is no more here, no longer staying in the place, and he has absconded, he has gone to some other state deliberately. Then what is the option?
That is what I am saying. First of all, he will have to issue notice. He will have to issue
No.
notice. And
If he is not there in the house, if he is not there in the station itself,
somebody will definitely be there. Somebody will definitely be there who will have to receive the summons on his behalf at his residence, or that very notice has to be affixed on the conspicuous place to assert and to say before the court of law tomorrow that for this reason he has not been arrested and he should be declared as an absconder. For the purpose of satisfying the court, he has to do all these procedures.
in an instant case, no such notice was issued.
No such notices, I'm coming to that. No such notices was issued. Simply on the prayer made by the investigating officer, the court was very pleased enough to allow the application, and on the very first day, on the day of filing of the application, the court has, without calling for the case diary and nothing.
Says that he has not been found in Teju, indicating that evading police arrest.
Yes, Your Sir. That is the issue. I was very much available. Still, I am there at Teju. Nothing has been done. That has been done simply on the prayer made by the investigating officer. That is what the person who is accused of a third category. I am coming to the third
So
category.
you mean to say that the IO don't want to arrest you, but then want to show that there is a warrant against you?
I don't know. I don't know why the investigating officer has adopted these tactics, because being cognizable offense, he had all the authority and he has the authority to make the arrest. Not necessary to obtain any kind of an arrest warrant. Since arrest warrant has been issued in this case, the legality of that is under challenge in this petition, because Your Lordship,
Since the IO is also not intending to arrest you, have you approached the court? Session court? Especially in this session only?
we have not filed any application for recalling of the order.
No, for anticipatory bail, because
Your Lordship.
he is not interested.
I'm very much aware.
I was not interested.
I don't know.
Otherwise,
Even my wife was accused of an offense, and he was issued with a 41A notice. 41A notice, to be very frank, 41A notice is not confined to the imprisonment for 7 years. It covers to all of the offenses beyond 7 years also. But then we always say that is 7 years.
then have you approached for bail, anticipatory bail?
No, not necessary. We did not apply.
Okay.
I did not. Now, non-bailable warrant of arrest has been issued against me. Now, the law says that remains in force unless and until that is executed. That is a very dangerous provision. Until I die, that remains in force. That is the consequence of law. That is the consequence of the non-bailable warrant of arrest. Now, directly coming to the case of Inder Mohan Goswami, Your Lordship, since this is the motion stage, Inder Mohan Goswami and another versus the state of Uttaranchal, Your Lordship, 2007, volume 12, SCC 1. In that case, very categorically, the Honorable Supreme Court has said that non-bailable warrant of arrest should not be issued by the courts in a casual manner. First of all other tactics and the tools has to be adopted, which is available under law. First of all, summons, thereafter bailable. And if these two options did not satisfy the requirement, at that eventuality only non-bailable warrant of arrest can be resorted to. Now,
so just a minute. What is the problem issuing 141 notice?
So, Your Lordship, the fact, everything, Your Lordship, they have already approached the court of session court under revision jurisdiction, Your Lordship. The issue here is, Your Lordship, so far as my learned brother has clearly submitted, Your Lordship, during the course of investigation also, it is well settled that warrant can be issued, Your Lordship. The warrant of non-bailable warrant of, what is the object behind issuing non-bailable warrant of arrest? To compel the attendance. And this is not issued by the court to aid the police. When it is executed or when he appeared before the concerned court, it is the court who will decide whether his custody should be given to the police or his custody should be sent to the judicial custody, or whether he's required for the custody interrogation or not. The court will grant bail also, Your Lordship. So now the remedy is before your lordship, is before the court who has issued it, your lordship. And so far as your lordship law is concerned, as my brother has fairly submitted, during the course of investigation also, non-bailable warrant can be issued. And so far as Inder Mohan Goswami case is concerned, the facts are different. In Inder Mohan Goswami case, the charge sheet was filed. The case is for trial, your lordship. Here, the Dawood Ibrahim case, it was, the judgment was, the fact was that during the course of investigation, whether the non-bailable warrant of arrest can be issued or not, and why non-bailable warrant of arrest is issued normally, your lordship. Later on, so that if the person remain abscond, then he may be declared as proclaimed offender under section 82. This is the procedure. The two are different aspects, your lordship. And he is not remediless, your lordship. He can always file an application under section 70 subsection 2, the repeal CRPC, before the concerned court who has issued it, your lordship. For recall of the court who has issued it, your lordship.
Yes.
It's under section 70 subsection 2, your lordship. The remedy is with them, your lordship. They can approach it, and he is fairly submitted that during the course of investigation, yes, the court can issue it. And the offense here is non-bailable offense, your lordship. How Inder Mohan Goswami case will come here when a person is committed a cognizable and non-bailable offense? How that accused will expect the bailable warrant will be issued? It's a non-bailable offense, and it is not issued after being charge sheet has been filed. Even, your lordship, the case laws, so far as the Inder Mohan Goswami case, in the other case laws regarding how the procedure has to be adopted for issuing non-bailable warrant, that will not come in this case because the facts are different. Every case has to be, your lord, considered with its own fact and circumstances. Here, your lordship, the Dawood Ibrahim case will apply, which my learned brother has indicated, your lordship. This is the, your lordship, the judgment passed by the Honorable Supreme Court in state through CBI versus Dawood Ibrahim case, your lordship. 2000, volume 10, SCC 438, your lordship. Here, your lordship, there has been discussed why non-bailable warrant is basically, your lordship, for compelling the attendance, and if he remained abscond, then proclamation, your lordship. There is a concept of proclamation is also there under CRPC. Your lordship may kindly come to para 22, your lordship. 22, 23, and 24, your lordship, of the state through CBI versus Dawood Ibrahim.
Yes.
22, may I read, your lordship?
Yes.
Another factor which clearly indicates that section 73 of the code give a power to the magistrate to issue warrant of arrest, and that too during investigation, is evident from the provision of part C of chapter 6 of code, which we have earlier adverted to. Needless to say that the provision of the proclamation and attachment as evinced therein is to compel the appearance of the person who is evading arrest. Now, the power of issuing a proclamation under section 82 quoted earlier can be exercised by a court only in respect of person against whom a warrant has been issued by it. In other words, unless the court issue a warrant, the provision of section 82 and the other sections that follow in that part cannot be invoked in situation where, in spite of its best effort, the police cannot arrest a person under section 41. Resultantly, if it has to be take the coercive measure for the apprehension of such a person, it has to approach the court to issue warrant of arrest under section 73. And if need to be invoked provision of the part C of the chapter 6, section 8.3 in case of a person accused of an offense under TADA. Para 23. Lastly, we may refer to section 90, which appear in part D of chapter 6 of the code and expressly state that the provision contained in the chapter relating to a summon and warrant and their issue, service, and execution shall, so far as may be, apply to every summon and every warrant of arrest issued under the code. Therefore, when a court issue a warrant of arrest, say under section 155 of the code, any step that it may have to subsequently take relating to that warrant of arrest can only be under chapter 6, 24. Now, this is relevant. Now that we have found section 73 of the code is of general application, and that in course of investigation, a court can issue a warrant in exercise of power thereunder to apprehend inter alia a person who is accused of a non-bailable offense and is awaiting arrest. We need answer the related question as to whether such issuance of warrant can be for the production before the police in aid of investigation. It cannot be gainsaid that a magistrate play not infrequently a role during investigation, in that on prayer of the investigation agency, he hold a test identification, record the confession of the accused or the state of a witness. statement of a witness or take or witnesses the taking of the specimen, handwriting, etc. However, the performing such or similar function, the magistrate does not exercise judicial discretion like while dealing with an accused of a non-bailable offense who is produced before him pursuant to a warrant of arrest issued under section 73. On such production, the court may either release him on bail under section 439 or authorize his detention in custody, either police or judicial, under section 167 of the code. Whether the magistrate on being moved by an investigation agency will entertain its prayer for police custody will be at his sole discretion, which has to be judicially exercised in accordance with section 167(3) of the code. Since warrant is and can be issued for appearance before the court only and not before the police, and since authorization for detention, police custody is neither to be given as a matter of course nor on a mere asking of the police, but only after exercise of judicial discretion based on the material placed before him, Mr. Desai was not absolutely right in his submission that the warrant of arrest under section 73 of the code could not be issued by the court solely for the production of the accused before the police in aid of the investigation. The court will decide whether the custody should be given to the police or court will keep the custody or he will be released on bail, your lordship. And the second remedy is he can approach the court who has issued it, your lordship, magistrate, under section 70 subsection 3. The law is well settled that this can be issued. So nothing wrong in the order passed by the learned magistrate court, your lordship.
May I submit, Your Lord?
Yes.
The extracts which has been read out by my learned brother is no, that is not disputed. That is settled. And myself has submitted, and that is not the issue. And the issue in that case was, in the case of Dawood Ibrahim, was whether the criminal court can issue any kind of warrant of arrest at this stage of investigation. The Honorable Supreme Court had, while referring to the provisions of 155 CRPC, had answered that yes, the court has the power and authority to issue non-bailable warrant of arrest under certain situations in terms of section 73, subsection 1 of the code. That is the issue. So, for the purpose of my application, the case of Dawood Ibrahim does not apply, number one, because that has been issued. We are not on the authority, we are on the procedural. I have relied upon certain judgments. The judgment of Guwahati High Court, Your Lordship, I have furnished Guwahati High Court judgment.
Yes.
The case of Tayyib Ali versus the state of Assam and another. Tayyib Ali, I have just furnished. Tayyib Ali versus the state of Assam. Yeah? No, that is not the one. Tayyib Ali, the other one? Just a minute. Criminal petition. Tayyib Ali, you are.
Where is that? Yes.
Tayyib Ali. In this case, the case of Inder Mohan Goswami has been referred to paragraph 8. Paragraph 8.
Yes.
Paragraph 8, page number 3. It is now well established by Honorable Supreme Court in a catena of decisions that non-bailable warrant of arrest should not be issued against the accused persons at the very instance without availing the other tools, such as summons, bailable warrant of arrest, etc., for procuring his attendance. Reference in this context can be made on a decision of the Honorable Supreme Court in Inder Mohan Goswami versus so-and-so. Paragraph 50, 51.
This must be in the trial
May I will
pending before the court.
I'm coming to that.
Okay.
I'm coming to that. Because when we come to the case of Dawood Ibrahim, the court has very categorically, the Honorable Supreme Court is very categorically said that Section 73 is of general application. It applies even during the course of investigation, even during the course of trial. Because there is no any provision in the CRPC which provides about issuance of non-bailable warrant of arrest during the trial and during the
During
court.
trial, it has to be, of course, for someone.
Yes,
But
that is
then-
what. Because Supreme Court has very clearly said that this is of general application. Now, paragraph 50, 51, 52, 53, 54, 55, 56, 57 has been applied.
Where it says that during investigation in the non-bailable or in the cognizable offense, it has to be issued a bailable offense, a bailable warrant.
Your Lordship,
Where do we find that?
I'm coming to other judgment also, that would be more clear.
Okay.
We are on Inder Mohan Goswami.
Because during trial, you can't compare.
I'm coming to that.
Okay.
I'm coming to that. That is, Section 73 has a general application. There is no any provision in the CRPC which provides about issuance of warrant of arrest during the course of investigation separately and during the course of trial separately. Because 73, as per Dawood Ibrahim's case, because the learned PP has also read out that Section 73 is a general application. We should not be confused on that. Paragraph 9, Your Lordship, case number 5. In the instant case, as stated in the foregoing paragraph, the learned court below at the very first instance had issued non-bailable warrant of arrest against the petitioner without using other tools such as summons, bailable warrant to secure the attendance of the petitioner. So accordingly, this
That is to secure the attendance of the petitioner before the court.
That
in the
is what-
trial. Then what I'm saying, what we are saying is someone has to be issued first. That
Yes,
is
sir.
clear.
Yes.
We should not be confused about it. But then here is the case where it is in the investigation stage.
No, Your Lordship. Why I am saying this is because 73, why I am reiterating this is Section 73 is the only provision which says about issuance of warrant of arrest. Issuance of warrant of arrest. Now, police has said that he has been evading arrest. Where is the provision in the CRPC which says that in case of evading of arrest during the course of investigation, the magistrate can apply other sections other than Section 73?
Here is the case where the accused was not found in the station at Teju.
Fact will be definitely different, Your Lordship. Here, the proposition of law is more important, which is applicable generally in all the cases, Your Lordship, which is applicable generally. Now, again coming to other case, Raghuvansh Devachan Bhasin, which I have furnished, Your Lordship. Now, by this judgment, Raghuvansh Devachan Bhasin. Yes. In this judgment, the Honorable Supreme Court, this was passed on subsequent to Inder Mohan Goswami's case, passed on September 9, 2011. Here, the Honorable Supreme Court has laid down the guidelines with a direction to all the high courts throughout the country to ensure compliance regarding the procedures to be adopted by the lower courts for the purpose of issuance of warrant of arrest. And this is the judgment passed by the Honorable Supreme Court, which stands binding in terms of Article 141. Paragraph 23, page 18. This is of general application. Fact is different. However, page 18, paragraph 23. However, before parting with the judgment, we feel that in order to prevent such a paradoxical situation, we are faced with in the instant case and to check or obviate the possibility of misuse of arrest of warrant. In addition to the statutory and constitutional requirements to which reference has been made above, it would be appropriate to issue the following guidelines to be adopted in all cases, Your Lordship. This is very important. All cases. This has not categorically defined.
No, the
Trial
misuse of an arrest warrant.
Yes,
So here is the case where the arrest warrant was also not required if he is present there.
that is what I am saying. What has
And then since he was not there in the station, clearly it reveals from the order that he was not available in Teju.
no, Your Lordship.
Then in that case, he has to go to some other jurisdiction.
That is the issue here. I am
Yes.
very much available. I have
Yes.
been alleged that I have been evading arrest. And where is the document? Where is the record? Because the court of law has to be satisfied as to how I have been evading arrest. Not at all. How can a person be said to be evading arrest when I am sitting at my home? Now, this is of general application. The following guidelines, Your Lordship, very important. The following guidelines is to be adopted in all cases where non-bailable warrants are issued by the courts. In all cases, this has not made any kind of difference at all. Now, number A is relevant. All the high courts should ensure that the subordinate courts use printed and machine numbered form number 2 for issuing warrant of arrest, and each form is duly accounted for. Now, page number 19, again relevant. Your Lordship, page number 19, clause E.
Yes.
Every court must maintain a register in the format given below. Must, it says must. And this is a criminal jurisprudence, in which each warrant of arrest, it has to be given literal interpretation. In which each warrant of arrest issued must be entered chronologically and serial number of such entry reflected on the top right hand of the process. Clause F. No warrant of arrest shall be issued. This is very important. No warrant of arrest shall be issued without being entered in the register mentioned above, and the concerned court shall periodically monitor the same to confirm that every such process is always returned to the court with due report and placed on the record of the concerned case. Again, clause G is also there. A register similar to the one in clause E, supra, shall be maintained in the concerned police station. The station house officer of the concerned police station shall ensure that each warrant of arrest issued by the court, when received, is duly entered in the
This is
state
true,
register.
this is true, but this whole
Yes.
applicable during trial.
Lordship, it says in all cases, Your Lord. It says in all cases. It doesn't differentiate during trial or during investigation. And because warrant of arrest has been issued, there is no any separate procedure for issuing warrant of arrest during the course of investigation. The court will have to trace to that provision of law, and that provision of law is found in section 73 of the CRPC. That is 73. If there is any provision regarding issuance of warrant of arrest during the course of investigation separately, I don't have anything to say, and I won't stress on the judgment of the Honorable Supreme Court in Bhasin's case.
And normally during the
Yes.
trial, if the court issued non-bearable warrant of arrest against the accused, then the date also is to be fixed, normally fixed, so that he is produced. But then here is the case where it's in the investigation stage, not
That is what I'm saying. That is what I'm saying.
Hmm.
What has prevented the police to use his power in terms of section 156 CRPC? Police has all the power to conduct the investigation in cognizable offenses. Needless to say that no warrant of arrest could have been obtained since the offense has been. Now, last part, paragraph 24 of this judgment.
Yes.
We expect and hope that all the high courts will issue appropriate directions in this behalf to the subordinate courts, which shall endeavor to put into practice the aforesaid directions at the earliest, preferably within 6 months from today. And this has been issued way back in the year 2011. Since decade past.
This is being followed only, I think, by the.
No,
trial
this
court.
is a judicial order, Your Lord. This
Yes,
is judicial
this is
judgment.
being followed,
No, Your Lordship.
not followed.
This has to be taken. This is not a case of win or losing, Your Lord. This is a judicial judgment, judicial order which has been passed by the top court of the country, Your Lordship.
Yeah, that
which
is why it
binding,
has been
which
followed.
stands
I
binding.
think.
It is not about a judgment has to be passed in my favor. This is a judicial order which has to be given effect. We cannot differentiate the judgment and the language which has been spoken by the Honorable Supreme Court by trying to stress that this is during the course of trial, this is during the course of investigation. Because even Dawood Ibrahim cases very categorically say that section 73 applies generally. That applies generally. And we are no one to argue on the case law declared by the Honorable Supreme Court, Your Lordship. And even this law, in this case, no such requirement has been complied with. And this has to be taken very serious note of. Now, clause F very clearly says that no warrant of arrest shall be issued. It uses the expression shall. It is not directory. It is mandatory. And this is a direction passed. This is a judicial order which has been passed in a judgment duly circulated to all the high courts throughout the country for its compliance. And the orders which have been passed by the Honorable Supreme Court cannot be taken that lightly, Your Lordship. So I pray that the warrant of arrest which has been issued by the Honorable CGM in a very casual manner without caring to call for the case diary even on the very first day of filing of the application.
So what next?
Your Lordship, this issue has been dealt by the Learned Session Court in revision. Your Lordship, may kindly come to page number 65, Your Lordship. Page number 65.
Because here,
This is the reason
Yes,
why
on
we have
record,
said
Your
that the Learned Sessions Court is wrong.
even the warrant of arrest.
Your Lordship, as per the above extract
beyond-
copies.
Beyond jurisdiction of the court, this will. The procedure laid down.
Page number 65, your lordship,
65, oh?
of this their petition, your lordship. They annexed the order of the learned session court.
Hmm. Yes.
Page, para 32, may I read, your lordship? 32 and 33 is the appropriate one. That
Okay.
issue was already raised before the learned session court. As per the above extra copy, it is to be mentioned here that though exact format of the register is not maintained, combined register with the record of the issue of each summon and warrant, particular case, reference, date of issue of such summon or warrant, and accused name are found. It has been further reported that the issue number is also written on each summon and warrant. Similarly, copies of the format of the NBWA issued by the learned CGM Teju against the revisionist accused through concerned SP, Anjao District, and OCPS Teju contain name and address of the accused, case reference, and date of issue of warrant directing the executing police authority to produce the absconding accused before him, magistrate, amongst other. Para 33. From the above material record available before this court, it appears that the direction of the Honorable Court in above cited case in regard to the format NBW and registered to be maintained is issuing court as well as the concerned police station has been substantially complied, if not minutely or exactly. Yes, it's correct, your lordship. And so submission and prayer of the learned PP has a force in law to the consider opinion of this court. The information whichever has been reflected in the direction given by the Honorable Supreme Court is all there, your lordship.
The judgment does not leave down any kind of an exception saying that the above directions, if substantially is complied with, then our directions mentioned here in above shall not be applicable.
If it is not compliant, then it will be amounting to contempt of the Honorable Supreme Court, not by this Honorable Court, decided by this Honorable
Your
Court.
Lordship, we are not quarreling on the judgment, Your Lordship, because we are here before as a court officer, we are here before the court of law for the purpose of enforcing the law which has been declared by this Honorable Supreme Court. The law does not, the guidelines which has been laid down by the Honorable Supreme Court does not lay down any kind of an exception.
You file an objection then?
Your lordship, objection, everything will be decided on the basis of record, your lordship.
Okay.
We don't need to
So,
bring any extra.
They have included this respondent also. Respondent, who is this?
He is the informant. In the interest
Informant.
of justice, he has been, because in criminal revision petition, he is supposed to be arrayed as a party respondent.
Yes, your lordship.
Since in that case, that is in continuation to the criminal revision petition, that is the reason why he has been arrayed
Okay,
as
well,
party.
issue notice then.
Yes, your lordship.
That is, this is prima facie, and warrant of arrest format has been very clearly, categorically provided in the judgment, your lordship.
Yes,
At the
yes,
last page, format of the register, and this is required to be complied. I don't know whether this record lies in the registry of this honorable court.
Hard Mr. C.W. Mantho. Land counsel for the petitioner. This is an application under section 528 of the BNS 2023, praying for passing and setting aside of the order dated 3/10/2024, passed by the Learned Session Judge Teju in criminal revision number, case number 02 within bracket L, capital L, bracket close stroke 2024, and order dated 8/4/2024, passed by the Learned Chief Judicial Magistrate Teju in GR case number 53/2024, corresponding to Teju PS case number 28/2024 under section 304/321 IPC. So, whereby the Learned Court has issued non-bailable warrant of arrest against the petition. So, that. No need to call for any record.
Your lordship, call for the record.
It will be required.
So far as your lordship is connected to the issuance of NBW.
Record from both.
Yes, learned magistrate court, your lordship.
Magistrate
As well as from the session court, your lordship.
Issue notice. So how long it will take?
3 weeks, your lordship.
Returnable by 3 weeks. Okay. Call for the trial to record from the CGM Teju as well as the session judge, session court,
Yes, your lordship.
Teju.
Thank you. In the revision, criminal revision number 2L 2024.
Call for the record of report from CGM Teju. In GR case number 53, 2024. And the session code. In criminal division case number 02 L, within bracket L 2024. Start. And since Mr. Ete appeared and accepted notice on behalf of the state respondent, no further notice is issued. Start. The petitioner shall take steps upon the respondent number 2 by a registered post with AD within 3 days from today. Start. List is matter after 3 weeks. Okay.
Obliged, Your Lordship.
Your Lordship, we made a prayer for interim, Your Lordship, since this is a prima facie case.
The interim order,
Yes.
the interim prayer shall be considered on the next stage.
All right.
Obliged.
Yes.
On the last occasion, I had sought for some more time to place some judgments before this honorable court.
Hmm?
On the last occasion, if your lordship
Okay.
will remember, I had sought for more time to submit some judgments before this honorable court.
Seeking for more
In-
time.
No. In the last occasion, Your Honor, this
Okay.
matter was taken up for motion on
Okay, you took time.
Friday. Yes, Your Honor.
Yes.
So by way of filing this petition, there are two main contentions, Your Honor,
Hmm,
that has been
yes.
made by the petitioner. First is that the Honorable Special Judge, NDPS Bomdila, had issued an NVWA to the accused person without first issuing a bailable warrant or considering his case for that matter. And the impugned order is the next hearing on. Is at page 124.
Okay, here is the case where your contention is that you have been granted bail by this court.
Yes, Your Honor.
So without cancelling the said bail.
Without cancellation of the bail order,
Okay.
the Honorable
But
Judge
then
will not have.
that probably was issued for non-appearance. You did not appear before the court for trial, and that is why the court has issued non-bailable warrant of arrest against.
Yes,
the
Your Honor.
accused.
Even then, the
So
Honorable
the
Judge
bail,
would have
the
followed the
earlier bail
procedure.
granted to you in the case is not connected with this present case.
But
Because
in the,
for
but-
that, the state has to file for cancellation for violation, but that was not done. It's not a case.
Yes, Your Honor.
The case, the present case probably is only because you did not appear before the trial court. And for non-appearance, on your non-appearance, the court has issued non-bailable warrant of arrest issued against you.
Yes,
So
Your
it is against that only,
Yes, Your Honor.
not against a cancellation or a grant of bail to you, but
But
by the
Your
court.
Your Honor, in that case, even if NBW is issued,
Hmm.
that automatically results in cancellation of bail.
No,
of the
here
accused
again,
person.
you did not appear in the first, on the first day.
But there should
And
be
then
at
you were
least an
asked to
order for
produce the
cancellation.
medical document. You were asked to produce medical document on the next day. On the
Yes, Your
next day also, you remain absent and no medical document were also produced. You were given an opportunity, and
Yes.
there also you remain absent. Then
But Your Honor, on the first day, the first day of absence, the accused person had filed for a dispense application, and that's the same was considered. And if Your Honor will see the order, that is the discretion of the court. However, there were other accused persons also who were absent,
Hmm.
and they had made the same excuse that they were absent because of illness. However, in their case, the production of medical document was not placed upon them, but only upon the accused person herein. And on the next date, when he did not appear, the honorable court should have at least given a chance for the accused person to appear by way of,
repeatedly you remain absent.
but it was only on first occasion. No? It was only on first occasion, and NBWAs should only be sent out by the learned judges only as a last resort. You know, if bailable warrants are not being executed or they are not being able to serve it to the
Is it different case?
accused person.
Your Lordship, here, Your Lordship, I would like to assist Your Lordship, here, when Your Lordship bail is granted by the Superior Court, even by the court itself, Your Lordship, if the IO apply for cancellation of bail, then Your Lordship, the procedure for cancellation of bail comes. But in these circumstances, in this present situation, Your Lordship, once the condition has not been fulfilled or violated, then Your Lordship, the court should cancel the bond. actually.
Earlier bail.
Yes, Your Lordship, bail bond, because Your Lordship, in existence of that bail order issued by the Superior Court by court itself also, that has to go first. And Your Lordship is well aware, the cancellation of bail bond and the cancellation of bail is more or less, Your Lordship, the consequences are similar, Your Lordship. I have some judgment on that for the better assistance of Your Lordship. That is the only issue here, Your Lordship. Whether the bail bond has to be forfeited first, Your Lordship.
Now, that means yes, of course. The court should have cancelled the earlier bail first.
Yes, bail, Your Lordship, bail bond. Your Lordship, the surety is there, no doubt, Your Lordship. And surety exists, execute the bail bond. And when, Your Lordship, the court make a summon to the concerned accused for afference, if he fail, then the concerned court should give a opportunity to the surety as well. Because the non-appearance, maybe it was not be deliberate one, Your Lordship. Or maybe it would be a deliberate one.
According to
The
her,
co-
it was not deliberate. She made an application for dispense.
Yes, Your
of
Lordship.
appearance on the first day.
Your Lordship, I am not, whether the order is correct or not, I am not on that, Your Lordship. I'm just on the procedure. Later I will come to that, Your Lordship. Now, Your Lordship, the thing is that for the cancellation of bail bond, Your Lordship, it clearly says the satisfaction, Your Lordship. Satisfaction to the court. And there are, Your Lordship, judgments from the various, Your Lordship, High Court reported in the SCC online, Your Lordship. Just for, Your Lordship, reference, Your Lordship, I would like to rely. Later on, we'll come to that, Your Lordship, whether this procedure has been duly complied with the learned trial court or not, Your Lordship. From para 14 to 23, I will read, Your Lordship.
That is true.
Para 14, Your
Very
Lordship.
good.
Yes.
Hmm?
Para 14, Your Lordship, this case is reported in 2009 SCC online KER 6601. From 14
Para-
onward.
para?
14. I will read, Your Lordship. Let's clear the procedure.
Yes.
Section 446A deal with the cancellation of bail bond. A joint reading of section 439, section 441 and 446A of the code so that when a person is granted bail by High Court or Session Court, he shall be released on bail only after execution of a bail bond as provided under section 441 of the code. If any condition is imposed by the High Court or the Session Court, such conditions shall also be incorporated in the bail bond. If any of such condition is violated by the accused and thereby such bond is forfeited by any person or persons who executed the bail bond, the bail is then cancelled by virtue of section 446A of the code. The cancellation of bail bond under section 446A of the code is an automatic eventuality and it occurs on account of breach of condition in the bail order and consequent forfeiture of the bail bond. Section 446A of the code does not make any difference in the case of bail bond executed on strength of bail order passed by the magistrate court or by the High Court or Session Court. It applies equally to the bail bond executed either on the basis of order passed under section 437 or under section 439 of the code, and the consequences under section 446 is same to such bond. If a bond is then cancelled under section 446A of the code as a consequences of violation of condition in the bail order, the magistrate is bound to proceed against the accused to procure his presence in court and also for forfeiture of bond. For this purpose, non-bailable warrant may be issued against him. If the accused is arrested and produced in the court, the magistrate may also commit him to custody subject to the provision of section 446A(b) of the code. Therefore, it follows that if any condition in the bail order issued by the Superior Court is violated, independently proceed against the accused for procuring his presence or to proceed against him for forfeiture of bond. It may not be necessary for him to address the High Court or Session Court to cancel bail under section 446A. Is not controlled by 437(5) or 439(2) of the code. Section 446A of the code deal with cancellation of bail bond, whereas 437(5) of or 439(2) is invoked for cancellation of bail. There is a difference between cancellation of bail bond and cancellation of bail. Cancellation of bail bond takes place automatically under section 446 of the code, whereas cancellation of bail is open order under section 436(5) or 439(2) of the code under exceptional circumstances. In fact, there is no provision in the code which in express term deal with power of the court to cancel bail, neither in section 437(5) nor in section 439(2) of the code. The expression cancellation of bail is in use. Going to the language of the code, what is contemplated under section 437(5) and section 439(2) of the code is only issuance of a direction to arrest and commit the accused to custody. But such power is often referred by the bench and the bar as cancellation of bail. And the said expression cancellation of bail is crystallized by its uses in various judgment pronouncement. However, before issuing a direction to arrest and commit the custody under section 437(5) or 439(2) of the code, it is necessary for the court concerned to cancel the bail, and this may be reason why reference is made in the precedent as cancellation of bail. To cancel the bail under section 435 or 439 of the code, very cogent and overwhelming reason are also to be stated. The court shall not cancel bail in a routine manner under section 437(5) or 439(2) of the code as per law. This is the settled position of law, but the position under section 446A of the code is totally different. If the magistrate court is satisfied that there is a breach of condition of bail bond and thereby forfeiture of the bond automatically cancel under section 446A of the code. However, a mere violation of condition in the bail order will not lead to automatic cancellation of the bail bond under 446A of the code. Apart from violation of condition in the bail order, the court must also satisfy, your lordship, here is said satisfied, that the bond is forfeited, then alone bail bond would stand cancelled and the accused can be proceeded against. It is the forfeiture of the bail bond which is crucial under section 446A of the code. If the breach of condition is not willful and is due to reason beyond his control, it cannot be said that there is a forfeiture of bond. The question is dealt in so and so. And it is thus held, a bond for appearance can be said to be forfeited only if there is a willful default on the part of the accused is not appearing before the court. It is needless to say that accused can be absent in court due to various reasons on a particular occasion. When the counsel files an application, it follows that the accused has vigilant and he has taken steps to instruct his counsel to file application. Such an accused cannot be. It is only in the case where there is willful default on the. In case of State of Kerala versus Anil Kumar, referring to the cancellation of bail, this court held thus an innocent violation of any condition imposed by court will ipso facto lead to cancellation of bail under section so and so. The crucial and vital question is whether there has been deliberate, contumacious and justified infraction of the condition imposed by the court. It is needless to say that if the court cannot cancel the bail, if violation of condition is not willful or deliberate, it is only reason to hold that such violation which is not willful or intentional shall not lead to automatic cancellation of bail bond under section 446A of the code. It must be borne in mind that whether bail bond cancelled under section 446A or bail is cancelled under section 437(5) or 439(2), the consequences which accused may face are more or less same. He may be arrested and committed to jail. Therefore, the court shall be extremely cautious and careful while proceeding against the accused on the ground that the bail bond is then cancelled. To sum up, I hold that if the magistrate come across with instance of violation of condition of bail, or if a report is filed by investigation officer before the magistrate pointing out violation of condition of bail granted by the superior court without there being any request for cancellation of bail, nothing prevents the magistrate from proceed against the accused under appropriate provision of law as indicated above. Nothing in the code prohibits the magistrate from proceeding against the accused if the bail bond executed on strength of the order issued by the High Court or the Court of Session is then cancelled under section 446A of the code. It is not even necessary for the magistrate to address the High Court or Session Court to cancel bail. However, if mere an application for cancellation bail granted by the High Court or Court of Session, the position will different and the magistrate court will have to proceed as per the settled legal position. Now coming to the fact, I find that the High Court passed the bail order in favor of third accused and he execute bail bond under so and so before the magistrate court. Therefore, he is released on bail by the magistrate court. If there is any violation of condition in the bail order, there may be breach of bail bond and forfeiture of bail bond. Therefore, instead of sending a report to this court, learned magistrate ought to have considered, this is the other aspect, your lordship. So now, your lordship, the procedure here is, if the condition is violated, your lordship, the magistrate can say forfeit the bail bond and then proceed with the issuance of non-bailable warrant of arrest against the accused to compel his presence, your lordship.
So he need to be issued.
And your lordship, the second issue is, now if the accused violate the, if does not appear, your lordship, whether the magistrate can directly forfeit the bail bond or not, this is dealt in, your lordship, in this judgment, your lordship, where it says,
It is to notice to be issued.
Principle of follow, your lordship, even in the cancellation of bail bond, your lordship. This is the other one. I will rely only para 4 and 6, your lordship. Just for the procedure part later. This is 2023 SCC online JNK 306 page number. Your lordship may kindly come to para 4.
What is that?
Paragraph 4, your lordship. High Court of Madras in case titled Prabha Bakran petitioner versus the state represented by Inspector of Police Lavinda Pati so and so, relied by learned counsel for petition. While considering the scope and import of section 446 of the Code of Criminal Procedure, in para 10 of the judgment at pages 182 and so held as under. I regret I am unable to pursue myself to agree with the said view taken by the Orissa High Court as well as Delhi High Court, wherein the learned judge have taken view that where there is a failure of the accused to appear before the court, no further inquiry or proof is necessary or contemplated for recording satisfaction. In my considered opinion, mere failure to appear before the court in absence of any willingness or part of the accused would not amount to a breach. Manifestly, there has to be animus on the part of the accused not to abide by or comply with the term and condition of the bond. Such animus alone make the failure of the accused to appear a breach in term of section 446 of the code. Such animus on the part of the accused could be ascertained only after affording sufficient opportunity to the accused on receipt of notice. If the accused satisfied the court that he was prevented from appearing before the court due to sufficient reason, the court may not record such satisfaction, holding that the accused has committed a breach of bond. The language proved to the satisfaction need to be underscored, which clear doubt if any that term proof held within its disproved by accused. Your lordship, here it says surety also. If accused is not found, then surety. Such proof or disproof of animus can be arrived at only after sufficient opportunity to the accused surety. Such opportunity shall satisfy the principle of natural justice or the altram patram, which is not alien to the criminal law as it has the sanction of the Constitution of India. Therefore, before recording such satisfaction, notice to the accused is necessary and further inquiry should follow. On such inquiry only, the court has to get satisfy himself on proof as to whether there was any breach of term of bond, and after so satisfied that breach has taken place, then only such recording of satisfaction of court will indicate breach of term bond. Now, your lordship may can directly come to para 6. Para 6. Ratio of the judgment of Prabhakaran versus Naratan Ram, with earlier Supra, make the legal position manifestly clear that before recording such satisfaction that breach has been committed, the court is required to issue notice, and after affording opportunity to offer any explanation, if the court is not satisfied with the said explanation offered by the accused, then the court has to record such satisfaction that the term of the bond have been breached, which alone signifies forfeiture of bond. Then, your lordship, the court can proceed. Your lordship. Because, your lordship, we are well settled that the validity of the bail order passed by the Superior Court, that will continue until or unless it is cancelled or trial is concluded, your lordship, or specific there is a conditional order by the higher court. So now in such situation, how to deal with it, your lordship? This is the procedure, your lordship, wherein no any requirement to filing a cancellation of cancellation of bail before the higher court who has issued it. Now, here now, your lordship, initially the order was passed in number 124, your lordship. Let us see whether now the procedure has been complied by the learned trial court or not. Then. Page 124, your lordship.
Yes.
May I read? Today, present case speaks for appearance of the accused. Accused person, namely Saiful Islam and Apu Wenia are present. Accused person, namely Asadul Ali is absent with steps. Accused Sian Chandra and here Kamaluddin, your lordship, is the present petitioner. Kamaluddin are absent without steps. Learned counsel Mr. A. Lamio has appeared for the accused Apu Wenia. T. N. Minto has appeared for the accused. Here it says, your lordship, Mr. T. N. Minto has appeared for accused Kamaluddin, and Mr. K. G. Songla for the accused Saiful Islam and Asadul Ali. Learned PP Miss L. D. Marekpa is present. Seen petition non so and so filed by Mr. K. G. Songla appearing for the accused, namely Asadul Ali. It is submitted that the Asadul Ali is suffering from ailment and not even in the position to appear before the court today. It is prayed that the personal appearance of the accused person may be dispensed with for today. Heard the prayer is allowed. Issued NBW against Kamaluddin with notice to his bailer, Your Lordship. Notice is fine, Your Lordship, but directly it issued NBW. First, notice is supposed to be issued to the bailer,
Yes.
and then the issue of NBW would have followed, Your Lordship. Now, the other page number 2125. Today, present case is fixed for appearance of accused person. Accused person name so and so are present. Accused person namely so and so is absent with this step. Accused and Kamaluddin are absent. So and so. Here also was absent, Your Lordship. But since the NBW has already been issued, Your Lordship, meaning thereby the bail bond was already cancelled. First, Your Lordship, the notice should have been issued to the bailer, the surety.
Yes.
And then the surety should have been directed to bring the accused. And then if he failed, then it should have forfeited the bail and issued NBW by discharging the surety as well.
This was issued on 23/2.
He's under custody. As on that, he is under custody.
Today, no, while issuing non-available warrant
Yes, Your Lordship.
to Kamaluddin, notice was also issued to.
Yes, Your
Bello.
Lordship.
Okay,
First,
then what
according,
next?
yes, Your Lordship. According to me, notice ought to have issued first.
Hmm.
Then, your next date, if he failed to bring the accused,
No, notice was issued,
yes,
page 16.
yes, NBW with notice.
Yeah, notice to the bailiff.
Yes, Your Lordship.
Okay, then what next?
Next, Your Lordship, next date he didn't appear. Your press again NW was issued again Kamaluddin and notice to the bailer. Perhaps the bailer also not appeared, Your Lordship, on the next subsequent date.
The next is
On the
18.
next date,
18/4.
8th of April, he appeared, Your Honor.
So 8 or okay.
And
8
that
or-
was the day when he was
April.
arrested.
So on this date,
He was
What
taken into
happened?
custody, Your Honor.
taken to custody.
Yes, Your Honor. And if Your Honor will see, it was in this order that the honorable judge had cancelled had forfeited the bond.
Lordship, in page number 129 of dated 8/4/2024, here in para 6, here Your Lordship, belatedly the bail bond was forfeited, Your Lordship.
So on the same day.
No, yeah, on the same day,
It
but
was later
belatedly, Your
on.
Lordship. NBW was initially issued
12,
on
12,
12/12/2023 and on
8/4/2024.
8/4/2024, after expiry of 4 months, the bond was forfeited, Your Lordship.
There is some other accused person.
There is some procedure error here. Need for orders should have been passed earlier before issuing the NBW, Your Lordship.
Okay, says that the certificate was not issued, therefore the NBW was issued.
Yes.
Okay, the cancellation should have been first.
Yes, Your Lordship.
So, but he has taken custody first.
Yes, Your Lordship. Then cancelled it, Your Lordship. That is the same situation before the Jharkhand High Court. We'll just read out, Your Lordship, what the order passed by the.
Just a minute. Just 1 minute.
Yes, Your Lordship.
Subsequently, bail bond forfeited.
Yes. It should have been done prior to issuing the NBW.
Prior to. No, NBW. no?
NBW was issued on 12/12/2023 and the bond was forfeited on 8/4/2024. Same, your lordship, para 5, your lordship, the order in such case, your lordship, the order passed by the High. The
Yes.
court has gone through the order dated 4/6/2016 and find that on the date, the petitioner were in attendance under section 317 of CRPC. However, the learned court has directed for issue of NVW and there is no order of bail bond cancellation. However, in the margin of the said order, it is mentioned that the bail is cancelled. It appears that in absence of any order of the learned court, the said act is done which is not in accordance with law, and the learned revisional court has also affirmed the said order. In view of the above, the order dated 4/6/2016 passed by the learned CGM, Deogar, as well as the order of the learned revision court dated so and so, passed in criminal revision number so and so, pending in the court of so and so, is set aside. The prayer made in IA number so and so for addition of the prayer in main quashing application in para 1 with regard to quashing of the order 1/19 and passed by learned special judge, whereby revision prepared by the petitioner against the order dated so and so has been rejected, is accordingly allowed and disposed of. Here, your lordship, the court has directed, your lordship, the petitioner are directed to appear before the learned court concerned on 15 fixing a date. If the petitioner appear before the learned court on the said date fixed by this court, the petitioner will be allowed to remain on same bail bond which has been cancelled. It is made clear that if the petitioner fail to appear on the said date fixed by this court before the learned court concerned, the learned court will proceed in the matter and take all coercive measure against the petitioner. Here also, your lordship, in the order, nothing was there regarding cancellation of bond, cancellation of bail. Only in margin it is written that bail has been cancelled, your lordship, which is not found to be in accordance with the law.
The bail bond standing against the accused
Yes.
person is forfeited.
Yes, your lordship. The said order was.
Bail granted has also not yet been cancelled.
Yes, your lordship. Your lordship,
Cancelled or
the,
not?
Not yet
your
been
lordship, if
cancelled.
the bond is forfeited, then automatically, your lordship, the bail will be cancelled.
It's cancelled or
Yes.
forfeited.
But the question here
cannot
is,
say.
yes, yeah, the bail bond has been forfeited on 23/2/2024, meaning thereby on that day, bail is then cancelled, your lordship. But the NBW, your lordship, NBW cannot be issued when the bail order is still in effect, your lordship. The bail order was issued on 12/12/2023, NBWA, your lordship, non-bailable warrant of arrest. In page 124.
Okay. So what need to be done? Any record need to be called or just on the basis of the records? This can be.
Your lordship, this can be done with the direction them to appear before the learned court, your lordship. Fixing a date, your
But he is
lordship.
inside the custody now.
He's already in custody.
Oh yes, your lord, fixing a date, then bail bond, your lordship, he has to be released because the bail bond has to be, your lordship, restored, your lordship, bond amount. And let the learned court below decide, your lordship. Because 12/12/23 order, your lordship, here, your lordship, the NBW was issued without cancellation of bail bond, your lordship. So this is the impugn order, your lordship. Yeah.
So he was arrested based on the impugn warrant issued against the accused on which date?
12/12/2023.
12/12/2023, your lordship, page 124.
What about this 23/2?
23/2, your lordship. Here again, the press NBW.
Subsequent NBWA.
Yes, subsequent press NBW
This
against
petition was filed, however, since
against the accused as well as the bailer, notice to the bailer again. And ultimately on 8/4/2024, bond was forfeited.
So he was arrested
he was arrested on 8/4/2024.
8/4/2024.
when he appeared.
Yes.
The personal appearance of the accused person also shows that he was not evading justice, Your Honor. His absence was not deliberate.
Who else is a respondent?
Here,
Only
Your-
state of eight.
It's a NDPS case, Your Lordship.
NDT.
Yes,
Okay, stay with me.
he stayed only, Your Lordship.
So what is your submission? Fine.
Your Lordship, according to Your Lordship, fairly submitting, Your Lordship, the procedure has not been compliant before issuing the NVW.
Full pass order.
Yes, Your Lordship. The bail bond should have been cancelled first by, in accordance with the law, then NVW ought to have issued. But here, the NVW was issued first and later on the bond was cancelled, Your Lordship. Procedural error.
Okay, hard miss.
PY Bhutia.
I'll take effect. Huh? Bhutia. Her name. Huh? Land counsel for the petition. This is an application filed under section 482 of the Code of Criminal Procedure. And I think it's one. Okay. I'll pass order.
Yes, Your Lordship.
Okay. Will resume at 2.
Yes, Your Lordship.
I beg to appear for the petition.
Lordship, I beg to mention item number 17 because my leading counsel is out of station due to medical ground. So I take counsel with,
17.
yes, Lordship.
You have urgent work.
No, Lordship, my leading counsel is out of station for medical ground. So I counsel with opposite.
Order column. Needs. Okay. You're for the petitioner.
No, respondent number 2.
Your name?
T. Takyang on behalf of my leading
Wait,
counsel
wait.
T. Topu.
Just a
T.
minute.
Topu. T.
Just a
Takyang.
Your name?
My lord T. Takyang.
Ita Kyang.
Yes, Lord.
Submits. Then advocate Ms. Ita Kyang submits that his senior is out of station. And out of station. Can pray for adjournment of the matter for. When do you want this matter to be listened?
After 2 weeks, my
After 2
lord.
weeks. He has also obtained consent from the land counsel for the petitioner. Accordingly, the prayer is allowed this matter after 2 weeks. Okay.
Thank you, Your Honor.
It has to be mentioned in the morning. Okay.
I beg to
Yes.
appear on behalf of the petition. My lord, I came before your lordship, my lord.
Item 6.
Item 6.
Okay. Yes.
This is the matter, my lord. This is the matter, my lord, our application was filed by a revenue officer under the GST Act before the, my lord, the current magistrate, asking for the, my lord, the non-bailable warrant against my clients and petitioner before your lordship. My lord, clients those are, my lord, the 4 brothers of one family. My lord, the GST officer went to Calcutta and, my lord, there is a search and seizure proceedings. In the search and seizure proceedings, my lord, against a company with whom we have no nexus. These petitions have no nexus with that company. There is company name.
Who are this petitioner?
My lord, one of the brother is a, my lord, the freelance accountant of the company in the year 2018-19.
2000?
Not now, it's 2018-19. Be it as it may, my lord. Be it as it may. some notice for appearance has been issued by the, my lord, the GST officer to my clients and the, my lord, petitioner before a lordship. My lord, we replied saying that why these notices, my lord, has been, my lord, served on us, and kindly let us know, my lord, why notice of appearance is required. My lord, kindly take page 38 once. Page 38. But page 39. I'm sorry, my lord, page 39. This is against the notice. This is called summons under the, my lord, the GST Act.
Yes.
But kindly take, my lord, I'm read for a lordship, my lord. But I have received summon under section 70 of the GST Act 2017 from your office. You have stated in the covering letter that summons was issued in connection with ongoing investigation against Messrs. Siddhi Vinayak Trade Merchants for issuing fake invoice. Siddhi Vinayak, my lord, Trade Merchants is a different company. We are no one to the, my lord, Siddhi Vinayak. And then, my lord, I could not able to understand the nexus between the seizure and ongoing investigation against the Siddhi Vinayak Trade Merchants. It is undisputed fact that the notice is a freelance accountant and temporarily worked under the instruction of different companies. Please provide me the documents, evidence in support of your reasons to believe to issue these summons to the notice. My lord, your lordship knows. My lord, there are, my lord, a catena of judgments, my lord, of the all the high courts, my lord, your lordship's judgments also, my lord. That, my lord, reasons to believe has to be formed and has to be, my lord, supplied to the, my lord, the notice. It is, my lord, well settled now in every, my lord, my lord, revenue law. But then, my lord, it is also submitted that it is impossible for the notice to make presence physically before the investigating or summoning officer. The notice is always cooperating with the revenue department and is duty bound to disclose relevant information. So, my lord, I want to cooperate. But notice could not able to understand as to why notice has been roped in the investigation. It is requested to you that please arrange virtual presence of the notice if required by the summoning officer after supply of relevant documents, evidences to the notice as stated above. It is reiterated in this regard that there is no nexus between the seized document as stated in the notice dated 3rd September 2024 and Messrs. Siddhi Vinayak Trade Merchants. It is stated that reasons to believe has not been supplied to the notice before seizure, thus the entire seizure was barren law. That is a different point. I am not coming before lordship on that point. But after this reply, they are not, my lord, communicated to us. There is no communication. They have not disposed of this reply, saying that no, we'll reject your prayer. But that has not happened. They have not rejected my prayer. Instead of that, my lord, they filed an application. My kindly take, my lord, page 20. This is one alarming. Kindly take page 20. They are an application before the, my lord, the concerned learned magistrate. This is a complaint case. Why, my lord, a GST officer filed a complaint case against a, my lord, witness? I don't know. I don't know. And, my lord, the prayer is at, my lord, page, my lord, prayer of this application is at, my lord, page, my lord, 33. Kindly take page 33. The prayer is, my lord, absurd. The absurdity on the galore and on the face of it, my lord.
Prayer at case.
Kindly take the prayer, my lord, page 33.
Yes.
Under the above facts and circumstances, I'm sorry, my lord. I'm sorry. My lord. Under the above facts and circumstances, the petitioner hearing most humbly prays that your honor to admit this petition, and after hearing the parties be pleased to issue a warrant of arrest. But why this is required, I don't know. Because the petitioner before lordship want to cooperate with the investigation. They want why they have been dragged into this investigating procedure. That is a matter of natural justice. And, my lord, I brought the judgments. Your lordship also knows those judgments, my lord. That, my lord, it has to be communicated to the, my lord, the noticee. Why he has been dragged to this investigation. But I am covered by Madras High Court judgment, my lord. I am placing that judgment. And, my lord, this fact, my lord, of my reply was placed in the, my lord, the petition. Kindly take, my lord, page 21, how they have dealt with, my lord. My lord, I'm sorry, my lord, page 31. Page 31, paragraph 19. How they have suppressed that facts, my lord. Only the response has been annexed. No statement, no averment to that effect that I am, my lord, these notices are want to cooperate with the investigation. It is a, my lord, clear abuse of process of law. There's an absurdity on the face of it. Kindly take, my lord, that Ashutosh Kumar Jha, Vipin Kumar Jha, Bittu Kumar Jha were summoned under section 70 of CGST Act. They have failed to comply. Nothing has been stated in the application that my lord, I have filed and replied. My lord, the natural justice has to be read into, my lord. The lordship knows. But my lord, I'm placing the judgment wherein, my lord, the Madras High Court said that, my lord, it has to be that, my lord, the why, my lord, someone has been issued has to be communicated. This is my lord, my lord, I'm
Application
seeking
for?
application for, my lord, the quashing of the, my lord, this complaint case, because, my lord, this is under, my lord, 528 of the, my lord, BNSS. This is a clear abuse of the, my lord, process of law. On earlier, in the earlier law, in the, my lord, the Code of Criminal
So
Procedure, that
according
is
to you, there is no complaint against you.
complaint against my clients. Complaint against my 4 clients
Hmm.
who have no nexus with the investigation. In spite of that, my clients wrote to them that, my lord, I want to cooperate. What information you need? Kindly specify what information you need.
Okay.
We have to come to the 900 kilometers
So-
from Calcutta or Bihar.
What is said thereafter, after the complaint?
Well, after the
After complaint, another warrant issue?
no warrant has been issued. My lord, they, my lord, kindly take page 19. They issued a summons from the, my lord, the court.
Someone issued.
Someone has been issued. Thereafter, my lord, after this
So
application,
this application was,
page 19 is the, my lord, the summon.
okay, 20 is application.
20 is the application. This is the
This was filed
annexure to
on-
the summon.
This was filed on October.
October.
So this summon is also on October.
Summon is, my lord, on 4th of October.
Okay, the application filed on 1st October. No order has yet been
No,
passed.
nothing has been, my lord.
Not yet.
Not yet. Nothing has
Okay.
been, my lord. That is, my lord, my lord,
What is your,
I took instruction, my lord, that, my lord, that there is nothing, no order has been passed, my lord, by the, my lord, the learned magistrate.
okay, so you are agreed by this summon?
I am agreed by the summon and the application. Where is, my lord, that there is a suppression is galore, whereby, my lord, the revenue
With regards to
officer,
the application, you can file objection.
my lord, I know, but, my lord, the why, my lord, your lordship knows, my lord, in section 482 also, what, my lord, that is, my lord, culminated in 528.
Hmm.
But why is this an abuse of process of law? This is a criminal proceeding.
Uh,
This is a criminal proceeding. Your
The
lordship knows.
Learned Court has not yet issued anything.
Well, I know, but, my lord, the genesis of the application is
You
bad.
received the copy.
I received the copy. The genesis of the application, why bad? My lord, a revenue officer filed an application before a magistrate seeking, my lord, arrest of, my lord, the witness. But this is unheard of. I never, my lord, I practice, my lord, the revenue law, my lord, before your lordship, my lord. It's unheard of in, my lord, in Indian law, my lord. So, my lord, today, my lord, my learned friend is here.
So with regards to someone,
Yes, my lord.
then they need your appearance. What
My
you
lord,
do with-
if I
with-
appear,
Hmm.
if I subject to the, my lord, subject to the, my lord, jurisdiction of the learned court, my lord, I cannot come back to your lordship and say this is an abuse of process of law. That is my understanding, and that is my humble prayer before your lordship. This is a clear abuse of process of law.
Okay, your grievance is that you are altogether
And
not
one
at all
of the-
connected with the case.
I do not have any nexus, though I want to cooperate. Only thing is that, my lord, I have asked to them, my lord, kindly give us, my lord, the why I have been required in the investigation. And that is, my lord, under
You are
law.
appearing-
My
you
lord.
are appearing on behalf.
Yes, I'm appearing on behalf of Central GST Commissioner, that central government as a special public prosecutor for them. So just we receive this copy, and this criminal petition is not a fit case. I will just establish now here only. So reason is that they in their page number 12 on ground they had clearly stated that it's too far to travel here. And second thing is that this notice to be served by the commissioner only under section 70 of
In reply to your summon, they are
Yes.
ready to cooperate.
That's why, Lordship. Yes, that's why. As per their annexer in page number 31.
Far away from the mic.
Yes.
Yes.
As per their petition, page number 31, 31, there is a 3 notice being issued by the commissioner under section 70. But after being exhausted by the IO, because there is a limitation in this power with the revenue officer. So after being exhausted, and this person is evading the tax, that's not only of 1-2 crore, it's about 685 crore. And now Arunachal Pradesh is losing 50 crore in this case. And there is an evasion of 99.50 crore. So central government is losing 50 crore and state government is losing 50 crore. And they created in the address of one person, Siddha Vinayak. That address is from Arunachal Pradesh, that's in Likavali. And Arunachal is one of the soft target for this type of racket. Now they have very big gang over here. So before issuing this notice, we inform the commissioner of this West Bengal, and this person, there is a malified intention. They have 2 addresses. One is in Bihar and one is in West Bengal. And they operate from there, and they get even notarized from this Changlang notary officer for the rent agreement also to establish this company. And meanwhile, that everything is on record. That's on digital record as per the IO. And those transaction evasion are on record. So that's why we are into the to interrogate this 4 person, because there are numbers of people involved here. So that's why we need the need custody for this 4 person. Therefore, we went to Kolkata to take the custody of them through the by informing the commissioner of Kolkata. And that's in page number 31 that notice has been served. But what happened, this person, Sonu Rai, he fainted, and later on next day, he said he admitted in hospital. So due to jurisdictional issue, and after being exhausted, and there's a very limited power under this GST Act of 2017. Therefore, for interstate means arrest, we need a proper direction from this Honorable Court of this learned JMFC, UPIA. So therefore, we approach UPIA, and there is no warrant, just there is a summon to appear there. Instead of appearing on 23rd of October, they empanel one advocate, and subsequently they're just saying that they will cooperate the IO of this case. My humble means praise that as on behalf of this respondent, since we are ready to pay the flight ticket also, if that person agree now before this honorable court also, we are ready to bear all the expenses. Just we need not before this honorable learned judicial magistrate. We need before the IO of this case. That's in offices in Naharlagan. That's Commissioner Central Government Itanagar. So he just need to appear before them with proper record just to answer. Since some of the seizure lists are also with as per the CDR record, and all the CDR record, there is a prima facie case already established. So that's why under section 70 of this GST Act, notice has been issued. And more than, if suppose evasion, tax evasion, ITC evasion is 5 crore, then it's non-bailable and 5-year punishment is there. So here, that person has been alleged under section 16 clause 4 and 132 of the Central GST Act. So just before instead of answering and replying or appearing before the commissioner and IO of this case, just this person is evading, and there are numbers of group of people over here. And Arunachal being one of the soft target, they're creating numbers of company. And even in their petition also, it's reflected. There are around more than 15,000 invoice being issued by them in their company name. And all those transactions and telephonic CDR also available with us. So there is a prima facie case is there. So it's not like there's no case. So that's why we approach Honorable Learned Judicial Magistrate UPIA to issue warrant, since we need the interrogation of this person, those 4 person. And because of them only, the government is losing day by day. Every day, they are creating different IP address and creating different company and issuing fake ITC.
With all those facts, the notice requires to please provide me, request that please provide me the documents, evidence in support of your reason to believe. Why don't you provide these, all these documents?
My lord, I'm bowed out to your lordship. This is a judgment, my lord.
Yes.
Fallen from your lordship.
Hmm.
This is a judgment, my lord. But directing them also, my lord, that the same, laid down the same law, my lord. This is required, my lord.
Why don't you provide the documents to this person?
Then, my lord,
Yeah.
then, my lord,
Lordship, they got this. That's why they filed this petition also. If you see annexer, page number 24, all the allegation has been well informed to this person. Because initially we visited in the month of August,
No,
and
just let's see the letter 18/9/24,
It's 39. My lord, I'm sorry, my lord. I'm sorry to say, my lord.
page 14.
My learned friend has
So
not
he's
taken
ready,
any
otherwise,
instruction.
ready to cooperate.
that's why if ready to cooperate, then we don't have any issue. But he has to appear in
Then-
person.
then When he asked for the copy, even if he had to appear also, he need to prepare what is the allegation against him.
I'm bowed down to your lordship.
That's there in notice, or Lordship.
Yes, you have to provide the copies. And then there is also alternate, they have also made request for virtual presence of the notice for video conference. And if it is not satisfied with, if you're not satisfied with that, then only, of course, can go for. Otherwise, if they're ready, what is the need for issuance of all those?
Lordship, it's very serious case. It's not a normal case.
No, that is,
So
that
that's
is
why
why
we
I'm
need
saying-
the
that is why I'm
custody,
saying you have
yes.
to follow the procedure, and you have to give the copies first, you have to give an opportunity to the other side. To the
Lordship,
person. And if they fail, thereafter only, of course, you can go for.
Lordship, we in person, we have given the notice and all the allegation.
No, you see, you have not reflected this reply to the notice also in your complaint. So this was given on 8/9, and this has not been reflected in the complaint case also, in your complaint case.
Okay.
This reply also not been reflected. Have you reflected? No.
Not
Okay,
reflected.
then, Lordship, a very short date may be given to file in opposition in affidavit.
Affidavit, you want to file affidavit?
Yes.
And then, my lord, I'm placing for the
What is this?
stay, my lord.
Lordship, meanwhile, because thing is that just we are also looking for his appearance only. And
Yes.
meanwhile, during this period, he may appear before the commissioner.
By this reply, he says that he is not connected.
He's,
And then he wants to know what is allegation against him. You should provide him, and then only, of course, if they fail, then only you can go for further. Isn't it? So what is what do you want to show?
My lord, kindly take the last paragraph, my lord. Kindly take the last paragraph, my lord. This is an investigation case, but they are also, my lord, they are seeking, my lord, the interference in the investigation. That means we are not seeking, my lord, the interference in the investigation. Court, my lord, declined to interfere, but, my lord, kindly take, my lord, on the paragraph 18. For the above reasons, while deciding to set aside the impugned summons, there will direct to the respondent number 2 and 3 to issue fresh summons, clearly indicating as to what purpose the petitioner is being summoned and what are the documents.
That is what they are seeking.
Absolutely. But I'm bowed down to your lordship.
Do that.
Lordship, in this regard, that short date, since that next date for this JMFC matter is in the month of December, so it may not be stayed. So short date, meanwhile, we can file in affidavit in opposition, and subsequently, since they are creating more numbers of those fake company, so that's the big issue.
Let them investigate against the Siddhi Binayak. Who am I?
Yes.
Mr. You are Mr. You are
My
Mr.
Devashish Ghosh.
Devashish Ghosh, Land Council for the petitioner. This is an application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita, within bracket BNSS, bracket close comma 2000. 23, paying for passing of the complaint case number 87 of 2024, pending before the Court of Judicial Magistrate First Class UPR. Oh, where is your prayer for passing of the notice?
Manat, kindly take my prayer. Prayer is at Manat page 15 of the petition. May I read, Manat? In the circumstances, it is humbly prayed that your lordship may be graciously pleased to issue a rule to calling upon the opposite party to show cause. While the complaint case was such and such before the learned Manat judicial magistrate, first class UPR, my lord, shall not be quashed and/or set aside. Call for the records, produce the same after hearing the cause that may be shown, and also after hearing all the parties to make the rule absolute and/or pass such order, my lord. And then, my lord, I am seeking for my lord, the interim order pending hearing of the rule. Your lordship,
challenge the notice.
but I am challenging the entire proceedings, my lord. That my lord, the 87. That is my lord, that is someone has my lord, the 87. Kindly take page 19, my lord. Page 19. CR case number 87 of 2024. And in the meantime, my lord, I can appear, my lord, virtually if they, my lord, provide me the documents, my lord. I don't know, my lord, the
Lordship, they can
this
appear
summon,
in
we have not
person.
challenge this summon.
my lord, the summon is in the, my lord, the case, my lord, I challenge the entire proceedings under the, my lord, say, my lord, 87 of 2024. If your lordship, my lord, want to, my lord, and grant leave, my lord, that prayer can be, my lord, added. Today, my lord, I am seeking for an interim relief, my lord. In the meantime, if they want, my lord, they supply us the, my lord, the documents and the, my lord, the reasons, we can appear virtually, my lord. We are ready to cooperate.
Fair enough. Issue notice. Returnable by?
Means in a week, next Monday, we will file affidavit in opposition. That
Okay, madam, I
matter
have
may
to
be listed as
I have to file rejoinder also, my lord.
2
Yeah.
weeks.
I have to file
one week's
rejoinder.
lordship. 1 week will they do. With we are the respondent. If we are ready,
If they file counter, my lord, then we have to file a rejoinder, my lord.
that's fine. We are ready to file within a week.
How many respondents?
No, one respondent, my lord. That's the, my lord, the officer who, my lord, filed this petition.
That's IO of the instant case.
Returnable by 3 weeks.
Lordship, short date may be given since
Record needs to
investigation.
call for any record?
My records of the investigation has to be, my lord, called for, because, my lord, that will show that my
Yes.
investigation not is against me, and those documents are not against me, against those, my lord, those
Call
companies.
for the scanned copy of the record. From superintendent of CGST.
Yes, Commissioner.
No, my lord, this is superintendent.
It-
filed
This
by-
is
Pleaded
filed by,
name.
yes, Superintendent of,
You have implemented by name.
yes.
Because,
Superintendent.
my lord, they have filed by name. But kindly take their petition.
No, this CGST
The state union
represented by this person,
represented by the.
not by the commissioner.
No, my lord. My lord, kindly take page 20, their application. Page 20, their application, they said so, my lord. At 20, my lord, last paragraph. That is also, my lord, there. I don't know, my lord, the commissioner is apprised of the fact or not, my lord. Page 20, last, my lord.
No,
State-
state union,
State
state.
union represented
Commissioner.
choose, my lord, Deep Pegu. My lord,
Whoever it
superintendent.
is, state represented through.
State, my lord, state has not with, my lord, state has not, my lord, making any investigation. This is, my lord, union CGST. And my learned friend also, my lord, from the CGST.
Through CGST. You are not implementing the state. Why?
But state I have not implemented, my lord, because my lord, the state
Not
has,
required.
no, my lord, I don't know, my lord, if your lordship, my lord, so my lord, I can, my lord.
Who represents the CGST?
GST is being represented by the Commissioner Itanagar.
I think you have to, you have to implement.
But kindly grant me leave. My junior will manage implement the state manage. State and commissioner of the Itanagar also manage can be implemented. As manage, I don't know manage commissioner has know these proceedings or not. Usually commissioner filed manage. Here manage the superintendent filed.
Yeah, but while implementing the department, you have to implement the commission. State through commission.
Well, the commissioner has not been
Commissioner.
made this application. Well, I can CGST authorities, represented by the superintendent has been filed the application before the learned magistrate. That is also I don't know that can be done or not. Commissioner has to come before your lordship.
Find out.
But kindly grant us leave, we will. We are ready to cooperate with everything,
Okay. Notice, huh? Okay. So notice is done about 3 weeks. Since Mr. Kipa. Your name is there?
My name is not there, This is
No,
not
no.
Gaily Tie, has been filed.
Your name, have you filed Wakalat Nama?
Yes, Lordship, I filed Wakalan morning.
No, I do not file the Wakalatnama.
Wakalatnama has been filed by me and the local juniors.
Local
It
juniors.
has been so that my all details have not been updated on the entire website till now. That's why it's not appearing there. But the Wakalatnama has been signed by me.
I think it needs to be filed by someone else.
And it has been filed by one local.
Probably you,
But I am the appearing counsel,
Senior counsel.
Calcutta,
Senior counsel.
Yes.
These are senior.
Yeah, he is a counsel.
He's a counsel, I am not the that senior counsel.
Okay.
Calcutta, we can't sign the Wakalatnama. So the counsels, only juniors briefed us. But that is the procedure adopted in Calcutta,
Okay. Then his name assisted by
Lalit Bhatt.
Lalit Bhatt. Okay. You have received the copy.
Just soft copy.
Signature,
They may serve hard copy also.
Appeared an accepted notice on behalf of the respondent. No formal notice. You will require extra copy?
Yes, hard copy I record.
Okay. Okay.
Yeah.
The formal, no, formal notice required, need to be issued. However, the petitioner shall furnish extra requisite extra copy to the learned counsel appearing on behalf of the respondent. So, as prayed for, the petitioner is also granted leave to implead the commissioner.
Yes, I'm grateful, Your Worship.
CGST and CX. State of Arunachal Pradesh. Huh? Prior to this, Mr. Kipa appear on accepted notice on no if after that, no? So Mr. Kipa also pray for some time.
Lordship, 2 weeks.
2 weeks time
Yes.
to file objection. Start the prayer is allowed. Okay, then thereafter this leave. Okay, the least this matter after.
But then we have to file a response to
Lordship,
that.
for correction, I will file within a week. I will file a affidavit within a week. It
Okay.
may be listed in within 2 weeks.
Okay, so least this matter after 2 weeks.
Yes.
If they served us the copy within a week,
Definitely will serve.
Take another week to file the response,
Okay, Mr. Kipa submits that the objection so will be filed. So there he will file objection within a week from today and serve copy to the learned counsel for the petitioner. So in such the petitioner shall also shall also file. He is also allowed to file rejoinder.
Rejoinder.
Okay. To the objection. Such objection to be filed by the learning council for the respondent within another week.
Yes, sir.
Okay, stop. At least this matter after 2 weeks. Stop, huh? Yeah. So according to you, this matter is fixed for December.
Yes,
On
December,
Okay.
16 December. So interim may not be since
I'm pressing for the interim, I don't know what will happen, they
Since-
will file or not. Then, what happened,
Lordship,
I
as
don't
per
know,
them,
now the prima facie case on balance of convenience is I have established before your lordship, kindly grant us stay,
Lordship, apart from that, even in their this petition, they have clearly stated they will cooperate and they will appear
Yes, yes,
before the
I will cooperate
uh,
virtually.
IO.
I will cooperate virtually, my lord.
That's why they doesn't have financial support to pay the
Okay,
transportation.
Para, the learning council for the petition of Faris submits that the petitioner is ready to cooperate with where have you stated that you are ready to cooperate?
Kindly take my reply, my lord, at page 39. All along, my lord, I am ready to cooperate virtually. The second last paragraph, my lord. Second last paragraph. It is requested to please arrange the virtual presence.
Okay. Ready to cooperate with the. This is called trial or the investigation? Before
But
that.
the inquiry and investigation, my lord, both, my lord.
Oh,
This is, my lord, all the, my lord, these billable sections and all this, my lord.
Lordship, it's
Revenue
not
law.
billable,
So,
it's
my lord, they have-
non-billable.
Yeah, it has to be culminated in the, my lord, the show cause, then, my lord, the demand against those companies, not against me.
Demand has already generated that so cause.
But I-
And
my lord,
repeated failure,
But I have not received any show cause, my lord. I have not received any show cause today. But they have to produce, my lord.
Ready to cooperate with the inquiry of the case. In view of the outcome, in view of the above submission, comma, your call is accused only. The petitioners are accused in the case.
yes, Lordship. All
Accused
four are
applicant.
alleged.
My lord, the witness to the, my lord, the inquiry. They are the, my lord, witness. They are not, my lord, related to the Siddhi Vinayak.
But then you are treated as accused only here in this case.
But that is,
Yes.
my lord, they made me accused before the, my lord, the learned magistrate.
It's clear there in page number 27,
What's
Lordship.
clear, it has
Page
to be
27,
decided.
27.
I don't know.
In-
They are accused. They are
Yes,
accused.
yes, in page 27, that's para 11, where all the CDA records are also there against them. Page 27, para 11.
No, so in the application, what you have? Accused persons, okay. The accused applicant shall be allowed to participate the inquiry through virtual presence. Through
Lordship,
video.
virtual.
In the meantime only, during this period only.
In the
During this
meantime,
period only.
that will help them. They have asked for that.
Okay.
Their personal presence is
Why personal
required.
presence?
Interrogation is required in this case.
In the meantime, till returnable that it is provided that the accused persons shall be allowed to be present in presence before the inquiry office through video conference, if required, by the summoning officer.
And the direction may be given to them, to supply me the documents, relevant
Stuff.
stuff.
The respondent stroke inquiry officer. Inquiry officer, it's called inquiry officer.
Inquiry investigating officer.
Investigating officer.
Investigating officer. Ah.
Yes.
shall also provide may also provide documents, stroke evidence in support of his reason to believe. To the accused person. To the accused person. Okay. So this is to be listed after 3.
And my lord, kindly stay there, madam. I don't know, my lord. If they, my
Lordship,
lord,
stay will
if
be
they
in
could not-
practice.
I don't know.
This is
if they-
only in December only.
Yes,
I know.
matter will be listed before that.
I don't know. I know, my lord. If they, my lord, if they could not file this, my lord, within a week, then my lord,
Lordship,
The next
kind
date,
of-
on the
Yes.
next date, the
Yes.
interpreter shall be
Even
considered
they
on
have
the
to
next
appear before there. That's only.
date. Next date.
my lord, kindly fix the date, then, my lord. Kindly fix the date, my lord, on the any date on the, my lord, Monday.
When do you want?
My lord, Monday, my lord, the first Monday of the month, the December.
Second.
I'm so
Okay,
grateful,
fix.
your lordship.
Then as prayed for by the Learning Council for the parties, list is matter on second, huh? Okay, and in the last, the interim prayer shall be considered on the next date.
I'm so grateful, your lordship.
Highly obliged.
Yes.
But please, Lordship, my lord, in this petition, we are challenging the, my lord, annexure 1, page 16 and 7, and 17, very small matter, my lord.
How
It
small?
can be disposed of.
16,
Yeah, page 16, my lord.
okay. What is this?
Your Lordship, you can see who has issued the order, my lord. Office of all 02 Gangbra and Gangburi, my lord, Welfare Association. My lord, this is not a village authority as defined in the.
Yes, association is not a.
Yes, it cannot be. That's the only simple prayer we are making, man. We have even, and page 17, man. These orders may be quashed. That's all we are praying, man.
Is it listed for?
For admission, man. We have taken justice service on the respondent 2, 3, and 4, man. We have to file affidavit also regarding that.
They have filed affidavit also?
Yes, Mullah. We have taken, they are not interested, Mullah. I think they know that it
Just a
would.
minute, what is this notice about?
Yes, they want to
This
settle the matter.
Order is about what? I haven't seen, huh? That is
Your Lordship may kindly say,
Hmm.
page 16.
Yes.
The complaint has been received on 3rd July from Sri Tao Rose, such and such, Yajari level, counter after failed to settle the case at village level council against one Sri Mating Tar Kanu, son of Sri Mating Tar Lanya of Comp village, POPC, district Lower Samosri AP, regarding money lending case, sum of rupees 28 lakhs 8,000 only. Therefore, under the provision of section 30 of Arunachal Pradesh regulation, District 1945, following GBC hereby appointed as arbitrator to hear the money lending case in between Sri Tao and Sri Mating Kani.
It doesn't have the power.
That's why, man. That's the simple prayer we are making, man.
Okay, so your prayer is, let us just see. Your
And man, they don't have the power to issue, man,
no,
this notice,
no, they don't.
order, and the notice, the second page, man. That's all we are saying.
This is the only impugn order.
Yes.
Okay.
But we are the parties, man, the person who is aggrieved can approach the appropriate forum, man, if they want, but not Gangbra and Gangburi Welfare Association. Even if we have annexed the civil courts, amendment that also in page 20, in that also there's nothing problem, but this Gangburi by forming an association can adjudicate. And definitely, and second prayer we are not stressing a
Respondent, you have implemented deputy commissioner.
yes, Mala. Deputy commissioner by the
And then who is this?
the performer respondent, Mala.
Then who is this private respondent?
Mala, first of all, private respondents, Mala, may see the
1, 2, 3.
yes.
And
They are
3, 4,
government.
5. So 2,
The
3,
2 is the president of all 02 Gangbra and the Gangburi Welfare Association.
And
He is a general secretary of that association.
are they the signatory to the impugn order?
Yes, Mala. 4 is the Mala complainant, Mala.
Okay, whether they are they contesting the case?
No, Mala, we have, Your Lordship, we have filed an affidavit, Mala, regarding the service of notice to them.
Does he?
Yes.
So whether the notice printed as completed?
24/8, Mala, we have filed.
date.
No, no, so whether any order passed, treating the notice completed,
I think 24/8 Lordship may see the order.
24/8,
Yes.
3/9, 24/8, no order.
We have filed on 24/8, my lord. That's the
Affidavit noted filed by the respondent,
24/8 we have filed.
24/8 you have
Yes.
filed.
Yes.
It's in the office. Has not yet filed any affidavit. So who filed affidavit?
We have filed.
No,
Petitioner.
affidavit,
No, we have filed, regarding dusty service upon them.
okay.
So in August, we have filed this affidavit.
Respondent number one,
One is, of course, Deputy Commissioner,
whether the one has filed any
No,
affidavit.
madam, we are performer responding only, we are not going to file.
So made prayer earlier to file affidavit.
No.
Because it says, the order says the respondent number one has not yet filed any their affidavit.
I don't think they require to
Correct,
file.
file their necessary affidavit within 4 weeks. Probably earlier you made a prayer.
But, frankly speaking, Deputy Commissioner has no role here. at this-
No role, not connected.
Yeah.
Because 38, Deputy Commissioner in, as per the earlier,
Earlier, it was
also
there.
Deputy
Now-
Commissioner had the power, but here they have already, they have passed order by themselves
Yes, madam.
without consulting Deputy Commissioner also.
Yes.
You have any submission?
No, madam.
Definitely, they will also accept, this is wrong,
Hmm.
And if private respondent number 2, 3, 4, we have served dusty, on dusty lordship, lordship may
Just
kindly.
a minute, sir. I haven't seen, so I'll, let me take the fact of the case.
What happened here? The respondent number 4,
Okay, hard, Mr. I'll just assist the court.
Yes.
Hard, Mr. Kapoor, Dana counsel for the petitioner. I've also heard Miss Wong, Dana additional people.
Government advocate, madam.
Hmm?
Government advocate, madam.
Is criminal only?
No, madam. This is not.
Civil?
Civil.
Civil
madam.
revision.
Okay. Okay, government advocate, government advocate, stop, appearing on behalf of the state, respondent number 1, stop, para. This is an application under Article 227 of the Constitution of India, praying for quashing and setting aside of the impugned order stroke summon. Summon also issued.
Yes.
Order or summon?
First is order and second is notice, summon notice.
Okay.
Lordship is 13/7.
Same date or different date?
3/7/2023 and 18/7/2023.
Just a minute, sir. Order dated 3/7/2023.
And notice dated
Issued by the GB.
all 02 Gangbura.
Issued by the President 01 or 02? 02.
All 02 Gangbura and Gangburi Association.
Issued by the President. The President 01 Gangbura. It's, the seal says 01.
Here, Lordship may say the
It's
impugn
02.
order, Madam.
Okay. All 02 Gambura and Gamburis Association.
Yes.
And the summon dated
18/7.
18/7/2023 issued by. This is also?
Same authority.
Okay. Okay. Then you say the notice, sorry, summon dated so and so, and notice dated 18/7/2023 issued by all 02 Gambura and Gamburi Association against the petitioner. Stop. What is the fact of the case? Where do I find?
Here, the matter was regarding money.
lending money, my lord. And it was between the respondent number 4 and the petitioner. And that was already settled between the parties, my lordship, can you see page 26, my lord. And typed copies starts from page 29. Typed copies more clear.
This is what, settlement?
Yes,
You took a loan from the
yes,
respondent number 4,
oh, yes.
and then you did not return.
And yes, no, by this settlement, I have returned. I paid the amount.
And then
Now, after this matter has been settled here in Naharlagan, sir.
then,
Now he goes to village and files a complaint before the
okay, complaint is also
authority.
there.
Malad.
Okay.
Respondent
Where,
number
where
four.
is the complaint?
Complaint copy, malad, we have stated category, malad. We
Yeah,
have
where-
sought copy,
where?
but
Have you annexed the complaint?
no. We have categorically stated in our petition that we sought for the copy, but they have not given one. They have
Okay.
issued this notice only. In order, malad, it's clearly reflected page 16, malad, that it's regarding money, malad. Regarding money lending case of 28.
Where
lakhs.
have you stated money, you took money and it was settled?
That. My lord, my
The
Catholic-
case of the petitioner is that in the, this is settlement order only.
Yes.
When you took money,
But it starts from paras 5 of our petition. Ma'am. Brief facts of the case, ma'am.
you took rupees
Yes.
5 lakhs.
Yes, Lord.
That the petitioner is that we took sum of rupees 5 lakhs from the respondent number 4.
Yes. So it was, my lord, agreed that it would be paid by 31st October 2023. But if the petitioner could not pay, so therefore
with the condition that
Yes.
he would
pay
repay,
extra 50,000.
he would repay
Yes.
the said amount
With
within
31st October 2023.
31st on or before the 31st October 2023.
Yes, ma'am. And if he could not pay, my lord, he,
However, he could not repay the same.
yes, 50,000 penalty would be there.
Okay. With the condition that he would pay
Yes.
on or before 31st October, and in case he failed to repay the same within the stipulated time, 50,000?
Yeah, 5 lakh, 50,000 penalty.
50,000 penalty
Yes.
would be imposed
Yes.
upon him.
Yes. The petitioner could not pay within that time period.
Okay, imposed upon him. However, the petitioner could not repay the said amount within the stipulated time. And then what happened?
Therefore, on 22/12/2022, the petitioner paid 5,50,000.
So, and on 22?
12/2022.
12/2022.
Yes.
The petitioner paid rupees 5,50,000 to the respondent number 4.
Yes.
Then?
Then they, this final settlement agreement, Lordship has already seen,
Stop.
page 29, this settlement was done.
On such payment, a final settlement was entered between the parties on when? 13?
Yes, the
13
13th
August,
August 2020.
13 2022.
Yes.
They were settling the matter once for all.
Yes.
Stop, huh? So the further condition is there.
No,
I think,
no, therefore, condition, this settlement is regarding, if he is not able to pay by 31st, he will pay 15,000 penalty, mal, this agreement.
Another,
No, no, that was the agreement, mal.
no, that was earlier,
Yes,
but then you, after your payment,
after this agreement, I have made the payment through RTGS manner. That I have categorically stated in para 5.
so this payment, 5,50,000 was after this agreement?
Yes, after this agreement.
No, no, then you have given me the wrong fact. You have given me wrong fact, yeah.
Malab, now fact is, Malab, 13 August 2022, this agreement was made, settlement agreement was made, that the amount would be paid before
And
31st.
when did you pay?
I paid this to RTGs on 22/12/2022.
22/12.
Yes.
So that is only after agreement. Settlement
Yeah,
was
after
done on
settlement.
13 August.
After settlement.
Settlement was done on 13 August.
Yes, yes,
Then it is just other way around only.
yes.
No, it was a wrong fact then. Then the first paragraph will go, huh? The first paragraph means the second, this paragraph.
Para 5,
You had to pay till October, huh?
Yes.
No, no, this October 2023. No, agreement was entered. Okay. Took a loan of rupees 5 lakhs. Cut all those. Took a loan of rupees 5 lakhs. Where is the loan document?
The loan documents are not there. The business transaction, it's already, it's written. Para 5, Lordship may kindly see, category is
Then leave that paragraph, entire paragraph. The brief fact of the case of the petitioner is that a monetary dispute arose between the petitioner and the respondent number 4 in relation to a business transaction amounting to rupees 5 lakhs. Stop, paragraph. No, not paragraph. Stop. Thereafter, comma, both the petitioner and the respondent number 4 mutually agreed to resolve their dispute amicably and executed a settlement agreement on 13/8/2022. Stop. The state agreement stipulated that the petitioner shall repay the loan amount of rupees 5 lakhs without interest on or before 31st/10/2023.
2022, Mala, that has been, that's why it was confusing, Mala.
2022, okay,
Yes, ma'am.
2022, stop. The said agreement further stipulated that the respondent number 4 shall, within a period of 7 days, remove the fence and notice board that he has erected from the in the lane of the petitioner. Stop. Furthermore, comma, in the event of the petitioner's failure to repay the loan amount along with what is the 50,000 loan amount, huh? The no, leave that, huh? Where is the condition that you'll pay 50,000 extra if you?
Mala, that was not there. The 50,000.
It was not there. What happened? Then where from you are submitting?
Therefore, madam, I here, madam, the lordship will just bear with me, madam. The agreement was that 31st October 2022, the amount would be paid, madam. Even if he is not able to pay, say Likha Khan and Neelam Tagore should be liable to pay the amount. That was the agreement, madam. The petitioner could not pay within that period, madam. Therefore, petitioner paid 50,000 extra, madam.
From his side?
Yes.
He decided?
To pay penalty 50,000 extra, madam. Therefore, on 22/12/2022, he paid 5,50,000 through RTGS, madam.
Okay, then furthermore, comma, in the event of the petitioner's failure to repay the loan amount, the guarantors of the petitioner, namely Sri Likha Khan and Sri Neelam Tagore, shall be liable to repay the loan amount.
Yes.
Stop. However, the petitioner could not repay the said amount within the stipulated time. Stop. Therefore, when it was paid then?
Madam, sir, 22/12/2022.
Therefore, a penalty of rupees 50,000 was imposed.
Yes.
By the arbitrators.
Yes, madam, in the agreement who are there.
Upon the petitioner, and accordingly, the said sum of rupees 50,000 was paid by the petitioner to the respondent number 4 on 22/12/2022.
Yes.
Stop. Thus, the petitioner has already made payment of the loan amount along with the penalty amount of rupees 50,000 to the respondent number 4 in his bank account. Stop. Then thereafter he lost.
Yes, madam. That madam, application we didn't get, madam, that we have categorically stated. And that thereafter we received this notice from there.
Okay.
Yes. That's
That's the matter. Okay.
Para 8, madam. Para 8, madam, we have categorically stated.
Okay. Para,
8.
However, when you received, after the gap of, after such payment, this was after gap of how many days?
Madam, after almost.
This payment was made on?
December, almost 8 months, madam.
Okay. However, after about 8 months of such repayment made by the petitioner to the respondent number 4, the petitioner had received the impugn order.
Yes. Order
Where
dated
is the impugn?
page 16, madam.
Okay, impugn order dated 3/7/2023 and subsequently
18/7.
Notice.
Yes.
Dated 18/7/2023 issued by the President all 02 Gaon Bura and Gaon Buris Association.
Yes.
For what?
It's his for settled money lending case, ma'am.
Okay. Contending that a complaint was received from the respondent number 4.
Yes.
Directing the petitioner where your appearance has been sought for.
Yes, Malad.
Where?
Malad, in page 16, the second para, last line, Malad. On 13 July 2023, at
Directing
General
the
Ground,
petitioner to appear before the
before the arbitrators. Malad.
before the arbitrator. Arbitrator was appointed by the Gambura.
Yes, Malad, that's it.
Arbitrator appointed by the Gambura Association, Gambura and Gamburi Association on 13/7/2023 at 10 a.m.
Yes.
at General Ground actually to settle
That's
settle the matter where
yes, just about the money lending case, Malad.
to
Arbitrate,
settle
here the money lending
to
case.
decide a money lending case.
Yes.
Subsequently, the said Gambura and all 02 Gambura and Gamburi Association. So the president, the president and secretary also.
Yes,
secretary,
President and Secretary.
the president and secretary of the Gambura and all 02 Gambura and Gamburi Association had issued second notice on 18/7/2023. They are also directing
Yes, Malad. If
directing the petitioner to appear before the
Yes.
said association, before the arbitrator, on when?
yes, Malad, on you've given Malad mercy. That the petitioners attend on 3rd August 2023 at Yachuli Ground. Last
To
page,
attend
page
on-
18, Malad.
Hmm?
Page 18, Lordship.
Page
So
18.
therefore, the above facts
To
are
appear before the arbitrator,
yes, Malad. So therefore,
appointed by the said Gambura and Gamburi Association on 3rd August
yes,
2023 at 10 a.m.
Yachuli Ground. Malad.
at Yachuli Ground.
Yes.
Stop, huh? Fair. Where have you stated that this Gambura has no right and authority?
Malad, Malad, page 9 starts from Malad. From there we have started. Page 9, 10. Page 9, Malad. By the impugn order, page 10, Malad. Impugn order, the impugn notice, petitioner has been directed to attend a court, 02 Gambura Association, which cannot be deemed to be a customer court within the meaning of Appeal Civil Courts Act 2021.
Where? Para?
Page 10, Lordship. The impugn order. From first line, Malad. The impugn order and impugn notice.
Okay.
The petitioner has been directed to attend court.
Para. The land council for the petitioner submits that the Gambura, the all 02 Gambura and Gamburi Association is not a customary court within the meaning of the Arunachal Pradesh Civil Code Act 2021.
Yes.
Stop. As such, the association does not have the jurisdiction to try civil dispute between the party and thereby the association has exercised the jurisdiction not conferred upon it. Stop. the Learning Council for the petition of the summary stat. In some frontier. What is this? Administration of justice within bracket, huh? Regulation 1945. The power to decide arbitration matter only lies with the deputy commissioner or assistant commissioner. No, leave that.
No, but I tried to say in this page 10 is Malak. Lordship is known that arbitration was earlier, Malak, the
So, but
powers.
this
powers
is
were-
repeal only, repeal.
Yes, that has already been repeated, Malak. Now the Lordship is in the Annexure 1. The Gambura and Gambir Welfare Association directed there should be an arbitration, Malak. The power of directing arbitration was earlier with Deputy Commissioner. Malak. That is already repealed by the Civil Codes Act 2021, Malak. Even if we assume, Malak, the Deputy Commissioner had the power, Malak, that has been repealed. That's the thing we
Okay,
want.
this is
Malak,
the fact of the case, that
yes,
much.
Malak, it's not required at all. But that's
Okay.
enough, Malak.
Okay.
Yes.
Okay. Miss Wong, Learning Council for the respondent. Number 1.
Malak,
Submit
she
that.
will also admit, Malak, doesn't have the power. So.
Fairly submitted that. As per the Arunachal Pradesh Civil Code Act, the Gamburas and Gamburis associations are not recognized as the customary code. Within the meaning of the, Gamburi associations does not come within the meaning of the customary code as per the said stuff. In the beginning, then this appearance of no one appears in the appearance. No one appears on behalf of the respondent number 2, 3, and 4. Although notice was served upon them. Okay. Okay. Then last. So then this.
So set aside in first that 2 orders. That's all. If the respondent, Malak, 2, 3, and 4 wants to, Malak, they can definitely approach the appropriate forum that we cannot stop.
So where is the provision under the act where you have annexed?
Annexed act, Malak, there's no such provision at all mentioned, Malak. That's why.
No, where is the provision where it says that the authority, village authority, 12 at 15?
Yes, Malak. Here it simply says, Malak,
hard for the Learning Council for the parties. Staff.
Malak,
Also there is the records or documents available on records. Staff. So the customary code. Where is the customary code?
It starts from page 25, Lordship. The amendment, it starts from section page 25.
Where is the customary code? Definition of the customary code.
That is in the regulation 1945, is section 5. Not here.
Not here?
Yes.
No, there is.
Here, kindly see,
E, customary code.
Yes.
Madam, it's page 22. The
Jurisdiction of civil court.
Yes, the courts, Madam, may see, Roman 2, Madam, up section of the 3, Madam, 10. The court assistant commissioner civil justice under Assam Frontier Adjustment Regulation. Madam, 2, Roman 2.
Assistant commissioner.
Yes, Madam. The
Yes,
courts
please.
of CC commencement of this act shall be deemed to be the courts of civil judge junior in respect of appeals that lie from customary until such time such appeals are. Now, Madam, what happened? That customary village authority is defined in section 5 of regulation 1940.
You have not annexed.
Madam, yes,
Section 5. Okay.
that is
Then-
there, Madam. The whole.
Then incorporate that one, quoting section 5.
Yes.
Okay. Keep the rest alone. Okay. Of the
Right.
last part,
Yes.
operative portion. Okay. Allow and dispose.
Yes.
Okay. Yes.
Your Lordship, Lordship, this is,
Yes.
this case pertains to quashing of an FIR which has been registered in connection with availing a job on the basis of an alleged false ST certificate. This is the case. Here, the allegation is that a group of persons, respondents, there are several respondents herein. There are 6 respondents, private respondents in total. They have filed an FIR before the OCPS at Tanagar, which has been, wherein the allegation was that the petitioner herein had obtained a job in the capacity of agriculture development officer in the state of Arunachal Pradesh while producing on the basis of a fake certificate. Now that has been registered, investigation has come into play, and the FIR and the investigation which has emanated from the registration of the FIR has been put to challenge by way of this petition. Now, there is an interim stay of the investigation of this case. Presently, the case is stayed. Now here, this case is absolutely based upon the judgment of the Honorable Supreme Court, wherein the Honorable Supreme Court is very categorically and very specifically said that in an allegation of obtaining a false social status certificate from any authority, no proceedings or no suit is permissible except a caste scrutiny committee duly constituted by the state government has to be there, and thereafter, if at all, subsequent thereto, after coming of the result from the caste scrutiny committee, a case can be instituted, be it criminal, be it civil, as the case may be. But then in absence of any report from the caste scrutiny committee, no proceedings is permissible. That is only the issue.
Whether the state have this committee?
The state did not, in this present case, nothing has been done in violation to the law laid down by the Honorable Supreme Court in Madhuri Patil's case. That has been registered and investigation has started. That is stayed now. And in this case, nothing has been done. As of now, I don't know what is there, but then this is the only issue.
Okay. So who appeared for that? Just a minute.
The case has been pending since long. The first order was passed by this honorable court on 20 April 2023. By order dated 24/2023.
Now, how many respondents are there?
Respondents,
Okay, so whether all are represented?
total respondents are 9, you know, 9
Nine.
respondents, 9 respondents.
Yes. 9
Yes,
private are also there.
yes, private.
So whether they appeared?
They have received the notice, but then they failed to appear. They received the notice,
Wakalatnama notice filed by the respondent number 4 to 9, not appeared,
not appeared.
appeared.
For their non-appearance, only the case has been pending since long.
Okay. But you are protected by the stay of the
I'm protected,
interim order, okay.
I'm protected. If the
So,
case is, I pray for disposal.
No,
Disposal of this
in their
case?
absent, who are they, these otherwise the private respondents?
They are the informants.
Informant.
Informants.
I think their presence is necessary.
That is the reason why we have been taking.
So
steps.
when did you take steps upon them? I think it was in the month of August only.
Yes.
April. You need to take fresh steps.
11/6/2024. Fresh steps is not required, Your Lordship.
Not
because-
required.
Not required. They have
No,
received.
6/8,
order.
last order, Wakalat Naman was filed.
11/6/2000. Your Lordship, 11/6/24 order is there, which says that the
Is it?
respondents have received the notice and the service. of
Office note, the last 34. Okay. 8/8, 11/6.
11/6/24. Your Lordship, the matter has been pending due to non-participation of the prior respondents.
Okay. What do
Earlier-
we do then? What do
Yes,
we do?
Your Lordship, earlier they were very interested in participation of the case, lodging the FIR, but then at this stage, it seems they are not interested.
Let us give them one more chance.
All right. Let the justice be. So,
Okay.
but then first steps, it may not be audible. Since
Heard Mr. Mantro, Land Counsel for the petitioner. I've also heard Mr. P. Land Additional Public Prosecutor for the state. No one appears on behalf of the respondent number
4 to 9.
4-2. Mr. They represent 1 to 3.
4 to 9.
Yes, Your Lordship.
Okay, for the 1 to 3, huh? And no one appears on behalf of the respondent number 4 to 9.
4 to 9. I'm appearing for 1 to 3, Your Lordship.
Yes. In absence of the private respondent number 4 to 9, this matter will stand again. List this matter after 3 weeks. Start. In the interim order passed earlier shall continue till the next day. Okay.
Lordship,
Alright.
I beg your pardon, not in this case, Your Lordship, in item number 4. In item number 4, I skipped to submit one thing, Your Lordship. In today's item number 4, record has been called from the lower courts, both from the CJM's court as well as from the Sessions Court.
Yes.
And there has to be an order saying that the record from the police station also be called, because this is connected.
Police station also.
Police station, because the judgment says that the police is also required to maintain the register. Record from the case diary as well as the record. From
Case diary is also there.
Case diary is required, Your Honor,
Yes.
as well as the case record
So,
from the OCPS Teju.
I think case diary was also.
Scan copy of case diary.
So in that case, item
number 4, please.
Item number 4, you have to correct it, saying otherwise case was called for, case record. Scan copy of the case record from the district judge, the session judge, and the CJM court. And then also scan copy of the case diary.
Case diary and the register.
What register?
Case register, because I'm relying upon the judgment of Honorable Supreme Court in Raghuvan's case, Your Lordship,
Register will be maintained by the court only.
as well as by the police station. There is a specific direction.
So someone
Yeah,
and the
that-
warrant issued, the police also
Yes,
issued.
similar register has to be maintained. There is a specific direction. This is a
Case-
judicial law.
case-
But Your Lordship, the issue here is if the register is called for, then all the other proceeding, other investigation process will be stalled. Your Lordship.
Scan copy.
Yes, scan copy of the register.
Scan copy of the case diary along with the register.
Yes, Your Lordship. Maintaining maintaining non-bailable warrant.
Okay, maintaining the known.
Warrant of
available
arrest. Warrant of arrest.
Of arrest issued against the accused, accused persons. Okay.
Obliged. We
This is in keep it in the same, because probably in that order, I think it is with the item. Okay, yes.
Lordship, actually it was supposed to appear from, yes, from VC, sir.
No one.
It should be on VC.
You are for?
I'm for respondent to.
Respondent?
Two.
Okay. For the petitioner? Yes.
Lordship, I am for
item
petitioner.
11. Yes.
Lordship, I am for petitioner Salil Pandya.
Yes. What is this case about?
Lordship, this is the application under section 528 of BNSS for quashing of FIR. Number 74 of dated 15th July 2024. Under section 318 of BNS registered at PS Naharlagun. Lordship, in this matter, petitioner and respondent number 2 both are businessmen and doing business of the kitchen steel equipments. There is a business transaction between the two and established contractual relationship. Both are in
But
business
you are for respondent
since
number
2019.
two. Okay.
Please, Lordship. Lordship,
Have you filed
on
any
the last
objection?
date of hearing,
Yes. Wait.
May I
wait,
proceed?
Just a minute. Huh? Have you filed any objection?
We have filed.
Lordship,
Just a minute. Just a minute.
Lordship, I'm actually assisting to this Mr.
Lordship,
Agarwal.
here I am. We are for war 2
He's
on VC. Yes, Ship, the objection has been duly filed. The counter reply has been filed on record.
You are for respondent or petitioner?
Respondent number 2, Lordship, the informant, the
I am
complainant.
for petitioner, Lordship. I am for
Okay.
petitioner.
You are for petitioner. But the respondent number 2 has filed any objection?
Yes, my lords. We have filed our
filed?
objection. Yes, my lords. And my lords, I would humbly like to inform this honorable court that in our counter reply, there is some inadvertent mistakes regarding the facts of the case. And the same can be like witnessed by way of written arguments, which has already been filed before this honorable court. So it's a humble submission that kindly the written arguments along with the counter affidavit may be read together. My lords, there are some inadvertent mistakes in the counter reply regarding the facts of the case. So this was highlighted to us later on. So we kindly seek your permission, either allow us to file an amended counter reply, or the counter reply maybe the mistakes can be ignored kindly and read with the written arguments.
Where is the office? No. Okay. Yes, Mr. Ape?
Yes, Your Lordship. On last occasion, Your Lordship, there was a direction from the Honorable Court to produce the case diary along with the 161 statement of the witnesses. Your Lordship. 161 statements are
Is it
there.
ready?
The statements are there, Your Lordship.
What is this by paper?
Sahil Pandya, Your Lordship, the earlier, there was a query whether the statement of the present petitioner was recorded or not. Your Lordship. This is recorded, the statement is here. Next week, the case diary.
Case diary, you have received the case diary?
Yes, Your Lordship. Earlier, they have filed an affidavit.
You have received the copy of the affidavit?
This is affidavit filed by the this petitioner, Your Lordship.
Yes, Lordship.
He's stating that his statement has been recorded. And in the case diary, Your Lordship, yes, his statement is there, Your Lordship. statement of Sri Salil Pandya under section 180, that is corresponding to 161 statement in connection with Nalagan PS case number 7421. Offense involved is 420, Your Lordship.
So what is to be done today?
It's for the admission, my lords.
Hmm?
It's for the admission.
Okay. The statement of the accused was to be perused by this court.
Yes, sir.
And also directed that in the meantime, the IO will record the statement of the petitioner.
Only thing here to ascertain whether it's a purely a commercial transaction or during the commercial transaction whether any offense has been committed or not. 420 years.
So what according to you,
According
whether any offense made up under 420?
there was no doubt, Your Lordship, there was a commercial transaction between both the parties.
Lordship, may I submit?
You are for?
Lordship,
Yes.
I am for petitioner.
Yes.
Lordship, on the last date of hearing, that is 22nd October, the Honorable Bench of Shri Arundev Chaudhary agreed that the dispute in civil dispute and arises out of commercial transactions between the both petitioner and respondent two. And they also agreed that the petitioner had appeared before IO on 29th September and got his statement recorded. And
My
also
lord,
grant
it is
liberty to record the statement of the petitioner once again, as provided under BNS, including through digital mode, and also directed the petitioner to cooperate with the IO and file the affidavit thereafter. And Lordship, the petitioner have filed the affidavit and also joined the investigation through Zoom meeting on 30th of October and record their statement and submitted all the documents required by the IO. That is actually, Lordship, in the FIR, the only allegation was that the petitioner is not the owner of the firm and he is not doing the business. Only this allegation is against the petitioner. And Lordship, I have filed actually my GST certificate, GST monthly return, and the photograph of the prepared items. Lordship, my case is only this, that on 14th May 2024, respondent number 2 approached the petitioner for ordering the commercial kitchen equipments and petitioner prepared the quotation of the said ordered items. The said quotation was agreed by the respondent number 2 and sum of rupees 4,50,000 paid to the petitioner. Then the respondent number 2 wanted to verify their items, so the petitioner sent a location of his office address of Kundli, Sonipat, Haryana to the respondent number 2, and then representative of the respondent number 2 verified the prepared item on 30th May 2024 and paid balance rupees of 4,50,000. Admittedly, I have received 9 lakh rupees from the respondent number 2. Lordship, and the respondent number 2 assured the petitioner that he would pick up the ready equipment himself to save his cartage fare 86,000 and told the petitioner that his delivery truck would pick up the furniture from the Kirti Nagar market, Delhi, and on its return, it would pick up the ready items from the petitioner godown as well. But even after 5 days, when the respondent did not pick up the items, Then the petitioner requested him to pay cartage charges of 86,000 as per the term of the quotation, and the said that he will itself send the ready items to his destination. Lordship, only dispute between the respondent and petitioner is that the cartage charges. Respondent number 2 want to save his cartage charges and don't want to pay the 86,000 to the petitioner. And petitioner has ready prepared the ordered item, but he refused to pick up because Lordship, the next order of the respondent number 2 was cancelled. The reason best known to him. And after repeatedly request, he refused to pick up the ordered item. Then Lordship, he started pressuring the petitioner to take his money back and lodge the FIR to the police station. Lordship, this is the dispute. There is a commercial transaction between the both, contractual relationship between the both, and this is the admitted fact. Lordship, I am fully cooperated with the investigation, Lordship. I have joined the investigation. I have submitted all the documents to the Honorable Court, Lordship, to the IO, Lordship. I have personally appeared before the IO on 30th, on 29th September, and joined the Zoom meeting also.
Okay, just a minute.
On 30/10/2024, by the order of this Honorable Court, his statement was recorded through VC, remote video conferencing by the IO.
Okay.
However, Your Lordship, he was supposed to submit certain documents which has been reflected here. And he, even in the 161 statement, he has accepted to provide all the request document as mentioned in the statement. But as on that, he has not submitted. Your Lordship may kindly see in the page number 22, and his statement is also marked there, Your Lordship. Investigation is still pending, Your Lordship, and he is appearing through virtual mode, Your Lordship. And the document has to be produced physically, Your Lordship.
So, what about the respondent number 2? Whether the respondent number 2 is out, has filed objection. You have filed objection.
Yes, my lords. We have filed objection. And my lords, may allow me kindly to make humble submission on the facts of the case. My lords, the fact is that we have placed the order and he was supposed to deliver the order by 31st of May, and to which we have been chasing him. One of our the witness named Vinod Kumar Punia also made visit to his place of business to ascertain whether he is the owner of Yuvraj Steel or not. And to that effect, he got to know that he was not the owner of the said business when this transaction was made. Lords, he has been evading. We have submitted the communication records, the investigating officer, which is marked as the WhatsApp communication in this case. My lords, be that as it may, even if it is a contractual transaction, I may be kindly allowed to read section 318 of the BNS, and wherein the proviso H clearly provides that A intentionally deceives Z into a belief that A has performed A's part of contract made with Z, which he has not performed, and thereby dishonestly induces Z to pay money. A cheats. My lords, it is a clear case. He has taken money on record. The money has duly been paid. There was no verification happened. Even when the investigating officer asked the accused regarding the verification of the said goods, no documentary evidence is provided by them. My lords, we have paid the full money. There has been clear communication that he has been evading us since 31st of May. Only message he has sent us was on 30th July, when after this FIR was lodged, only with the intent to give this criminal case a civil nature. That's it, my lords. They have been clearly absconding. They have not submitted any iota of evidence, even in their petition. If this was the case, they would have submitted any documents on the petition. They are just misleading
Lordship,
this court.
I have filed my affidavit on 2nd November. Kindly see my
Lord,
affidavit.
it has
I
not been
annexed
served upon us.
all the documents. My
It has
GST
not been
certificate,
served upon us.
Lordship, my
And
return
your lord,
that
and your lordship,
clearly prove
just a
that.
minute. Lordship,
But
we
there has
have
been
to-
statement
we-
of
We have, we have to understand one thing, the investigation is in progress. As your lordship is well aware, that accused do not have any right to produce any document at this stage. The only thing he can do is to, no doubt he is cooperating, he is appear.
Based on the police report.
Yes, your lordship. He can produce all the document before the police, not before this court by through way of affidavit. That the court has to look into the material which has been produced by the prosecution, not by the accused at this stage. Because at this stage, the prosecution has, this accused has no right to be heard until unless he.
After completion of investigation.
Yes, your lordship. Absolutely, your lordship.
No.
Yes, your lordship.
No.
Now all facts are hazy at this stage because investigation has to be completed first, your lordship.
Yes. It's not the case that the case has been submitted into charge sheet.
Yes, your lordship. It's pending, it's still pending. And moreover, no
Now,
other document.
How do we interfere? How do you expect this court to interfere with the investigation of the case when there is a prima facie case against you?
Lordship, I have filed my affidavit. Kindly see, I have attached my proof.
No.
They are saying I am not owner.
Cannot.
I am owner of the firm. I am doing business. I am ready to deliver. Lordship, I am ready to deliver the items. I never refuse to deliver the items. Items are prepared. They refuse to pick up.
To you. The case is that is up to you. The case is still under investigation.
Yes, Lordship. I am cooperating. Lordship, I am cooperating. I am joining the investigation. I am cooperating, Lordship.
So how do we set aside the FIR or the investigation? How do we interfere?
Lordship,
Investigation of the
I have no intention to commit fraud, Lordship. I have no fault, Lordship. I have prepared the item. When the respondent number 2 refused to pick up, then what can I do, Lordship? I am still ready to deliver the items, Lordship. I am still ready.
What we'll do is we'll dispose of this matter day after tomorrow.
Okay.
Let us get it listed day after tomorrow. Today we have less time. We have some other matter also. So let me also go through the record and we'll dispose of.
Yes, your lordship.
Day after tomorrow, I think it's Wednesday. There will be
Right, Lordship.
on Thursday.
Okay, your lordship.
Okay, on Thursday. We'll dispose of on Thursday.
Right.
Okay.
Obliged, my lords.
And your lord, CD, if your lordship. Your lordship, if
you
CD is
can
retained,
retain
then
it.
it may be kept in a closed envelope because it's a confidential
You can
one.
retain it. You can retain it.
Yes.
Produce on the same day.
Okay,
That day. Okay. Return it, huh?
Obliged.
Mr. V. Singh, Learning Counsel for the petitioner, is present. Hard, Mr. V. Singh, Learning Counsel for the petitioner. I've also heard Mr. That is respondent number 1.
Yes, your lordship, I'm mistaken.
Okay. Additional PP for the respondent number 1. And I've also heard. Who is Mr.
Aditya Agarwal, my lords.
Adi?
Aditya Agarwal, my lords.
Aditya Agarwal.
Aditya Agarwal, Learning Counsel
Respondent number
on
2.
behalf of the respondent number 2. Huh? So, list this matter again on Thursday.
Yes.
For further hearing.
Yes.
Okay. On which date, Mr. Ate shall produce the CD?
Yes, sir.
Okay.
Obliged.
Obliged, sir.
Obliged.
Okay. Yes.
My lordship. Here in my lordship, engaged counsel Jejini is having some personal difficulties.
Okay.
He could not appear today.
You're Mr.
T. Tarin.
T. Tarin, Learning Counsel, appearing on the submit that the leading counsel.
Yes.
Mr. T. Tara has some personal difficulties today and pray for listing this matter after 3 weeks.
Monday, your lordship. Maybe on Monday. 2 weeks, your lordship. 2 weeks.
After?
2 weeks. 2
2
weeks.
weeks. Okay. After 2 weeks. Prayer list this matter after 2 weeks. Okay.
Obliged.
Yeah, Your Honor. I'm for the appellant.
Yes.
My lord, this is appeal for setting aside the impugned judgment passed by the learned civil judge senior division UPI. And today they are supposed to file the reply.
We file.
My lord, actually reply could not be filed because the respondent.
How much time you want?
2 week time.
Okay, Mr. Learned counsel for the respondent. Oh, sorry. Your phone? Respondent number?
Sole respondent.
So, okay, sole respondent. Prays for further 2 weeks time to file. Affidavit.
My lord, there is an interim order. Let me continue.
Prayer is allowed. List this matter after 2 weeks. Stop. The interim order passed earlier shall continue till the next day. Mr. P. Rahul, Learned counsel for the petition, is also appearance is also present. No interim order?
Yes.
What interim order is there? When it was passed?
It was passed on, my lord, 16/1/2023.
16?
16/1/2023.
1.
Yes, my lord. So the money execution number 23/2022 shall be stayed till further orders. That is the order, my lord.
Sixteen 1/2023.
Yes, my lord.
No idea. It's not available here on record. Where is the office? No, order is not available here.
Okay, my lord, it is not there then.
Do you have the copy?
I have the copy.
My lord, may I try to? My lord, actually, this appeal was filed before this honorable court with, along with application IA for condonation of delay of 86 days.
Okay.
And that was dismissed by this honorable.
Then how it has been, been registered?
It has been dismissed by this honorable court and being agreed
That
with
cannot,
that order.
that cannot be. It has been registered after condonation of delay only.
Yes. No, my lord, I am afraid.
Yes.
Before this.
Any other IA? Okay. In the interim order passed earlier shall continue till the next day. You should have given original one copy.
My lord,
There is, yeah.
IA has been already disposed of.
Not IA, it's not IA. But then in IA only there is a stay.
My lord,
Court stay
staying the money execution,
Money execution.
which is before the CGM court, Your Honor. My lord.
This is in IA, but then in the IA, in the meantime, it is provided that the execution proceeding of in money execution number so and so arising out of money suit pending in the court of leading learned civil judge, senior division UPS shall remain stay until further order.
Yes,
It
that
is
is
there.
there, my lord.
It is there.
That is there, my.
Hmm.
But being agreed with the IA,
Okay.
order of the IA,
Hmm.
the section 1909/2023, there is a order.
19?
My lord, may kindly. in the
19?
report,
Order dated
19/09/2023.
19/9/2023.
Yes, the IA was already disposed of and it was dismissed. Being agreed with this order, the appellant went to the Supreme Court.
Don't make wrong submission. Unless you properly assist the courts or the learned counsel, it will be difficult for a court to pass appropriate order. I stand disposed of.
This IA was disposed of on dismiss. And being agreed with this, this order, my lord. The appellant went to the Supreme Court and Supreme Court has set aside the, this, order of the 19/9/2023.
So this is, the appeal itself has been dismissed by this order.
Yes,
Consequently,
my
the
lord, it
connected
was
appeal is
dismissed
dismissed.
earlier, but it was restored by then, by the Supreme Court. By
Yes,
order dated 19.
It was restored.
Yes, yes, ma'am.
It
By
was
which order?
restored.
By which order?
Order is here, my lord.
This is Supreme Court order.
Yes, but in the order, your lordship, there are three observation has been made. The, in serial number 3, your lordship. Pending applications, if any, shall be.
Serial number 3
disposed
means?
of.
Serial number 3 means?
In order, your lordship.
Okay.
Pending
application.
applications, if any, shall be stand disposed of. So there is no any
No, that is
application has been pending.
No, pending application, if any.
Yes,
That is, they are talking about the pending application before the Supreme Court. It did not say that it's before the High Court.
My lord, that is for the High Court, not for the CGM court. That order is.
Please, learned counsel, please assist the court properly, huh? Both. You cannot go and go through entire records in few hours. Sometimes it's not possible. Especially if we have not come across earlier. Okay, the first appeal was restored.
yes.
We further direct that the appellant shall pay cost modified to rupees 50,000 within a period of 4 weeks. You paid rupees 50,000?
Yes, my lord, we have already
Okay.
submitted, deposited.
So then it is restored, it is restored only.
It has been restored, your lordship.
Then
That Supreme Court order is for restoring, restoration only.
you pray for how much time? 2 weeks.
2 weeks.
Okay. File. To file? Affidavit. Affidavit in opposition. Can you file affidavit in opposition in first appeal? But the record was already called for.
Yes, record was free.
No, earlier, after dismissal, after restoring, probably at the time of disposal, if even if the record was called for, must have sent back. How many respondents are there?
Only
Counsel
one
for the
respondent.
petition, huh?
Only one.
Okay. Okay, have we received the record? Record received, okay. Okay, both the land council for the parties are present, huh? Record. Should take trial to TCA, received, list this matter after 2 weeks for admission, okay. Yes.
Obliged.
Here I am for the petitioner, Your Honor. Your Honor, here is
Your Honor, one correction is there. For this, Your Honor, IA is filed in CRP, Your Honor, 26, Your Honor.
you wanted to file objection?
No,
The
your
respondent.
I am for the petitioner, Your Honor.
Okay. In the earlier occasion, you have made prayer for some time to file objection.
Yeah, it was threat by the opposite party. Your Honor.
Have you filed? No.
No, madam.
Okay. How much time?
Madam,
Mr.
there is confusion, madam. The IA has been, IA is filed for CRP 26, madam.
Technically, Your Honor, that as per this record is IA number 92 is filed in CR 26, Your Honor. This is item number 14 and 15 related case, Your Honor.
Yes, IA 14 is in.
IA 96.
Okay. Mr.
M. Doji, madam.
Praise for further 2 weeks time to file objection. We are not objectors.
My lord, I am appearing in CRP number 31,
31.
2022, madam.
So the
There is no IA,
IA
madam.
92 is which,
IA 92 is for CRP number 26, madam.
Yes, Your Honor.
but all are listed. It's analogous. IA 92 of so and so with CRP 31 and with CRP 26.
No, Your Honor. IA is only filed for
Okay.
CR 26, Your Honor.
Okay, in IA, huh? In IA, that will be in IA.
However, my lord, I am not appearing in CRP 26, my lord.
Okay. That will be in item 14. Prayer allowed. List this matter after 2 weeks.
After 2 weeks, madam.
3 weeks. Okay. For 3 weeks then, huh? Okay, then 15 is different.
Yeah, Your Honor, this is a same matter, but Your Honor,
Okay. Then in
same issue, Your Honor.
so you are not here in item 15.
No, my lord, I am not appearing in item number 15, my lord.
So who
I am
is
appearing
responding in
for CRP
item
31, my
15?
lord.
Who is for the respondent?
Your Honor, earlier it was represented by, there might be some misunderstanding, but represented by opposite party, Your Honor. That, counsel for the opposite
M.
party.
Doji, that
Yes, Your
counsel
Honor.
for the respondent press for, and who will stand?
Well, it might be on.
Respondent, okay. Okay, Mr.
J. Kata, Your Honor.
Learning counsel for the petitioner is present. No one appears on behalf of the respondent. In absence of the respondent, the matter stand adjourned. List this matter after 3 weeks. Okay. That is in 15, huh? Okay.
May
Yes.
please, Your Lordship.
Yeah.
It's a prayer for quashment of the criminal proceedings and the charge sheet. On the last occasion and as well as previous occasions, we were directed to take steps. We had taken steps. And today I've been informed by Mr. D. Gogoi that he missed out the case. He could not come. He will be appearing for the Forest Department of the Government of Assam. And I'm also told that there has been a move by the Government of Assam to appoint some counsel to represent the Assam government. The Lordship, on some other day, this could be fixed after some time.
Okay. Mr. P. Dinaya, Learning counsel for the petitioner.
I'm for this step. Number 1, 2,
Your
and 3.
1, 2, and 3.
3 Lordship.
Okay. 2 also, Mrs.
Okay.
Which, Lakshmi, Learned ADPP for the corresponding number 1, 2, and 3.
Lordship, 2 and 3 Lordship, private party. I'm sorry, Lordship, it's a by name Lordship.
Respondent,
Only one.
No one appears on behalf of the respondent number 2 and 3. Have you taken steps? Upon
We have, including through the OC.
OC.
Through the OC.
But it has service report not yet received in respect of respondent number 4 to 8.
4 to 8, my lord, Assam government.
Assam
But,
government.
I have been informed that, of course, unofficially, my lord,
Okay.
that they would be appearing. In fact, Mr. D. Gogoi requested me to inform lordships. So
Okay.
he would not- He would
So
appear on,
whatever, in the office note also, nothing has been reflected with regards to the respondent number 2 and 3.
we took steps to the OC as well, my lord.
So OC.
Through OC.
So this 4 to 9 has never appeared earlier.
4 to 8, they have not appeared.
It did not appear.
In the principal seat, they appeared.
They appeared.
In the
So
principal.
there is a similar case in the principal seat also.
No, this has been transferred, my lord.
Okay, this is okay. So thereafter notice was issued. I
Yes.
think they know this
They know.
case has been transferred.
In
Okay.
fact, I have the copies of communication, but unofficially.
Okay, then what they,
My lord, Mr. D. Gogoi has been engaged for respondent number 5 and 8.
okay,
And in fact, the AG Assam was requested to appoint the counsel on behalf of 4, 6, and 7.
okay, at the moment then we'll only say that they are not present.
Not present.
Okay. So this is, if this is verbal, then we cannot also
Yes,
say
my
that if they have received.
In fact, I have copies of the communication, but I cannot produce them, my lord.
Okay. No one appears on behalf of the respondent number 2, 3, and 4 to 8. So the office notes dated 2/11/2024 reflect that the service upon the respondent number 4 to 8 will be still awaited. Okay, in view of the above, this matter,
If it is not inconvenient on 16th of December, my lord.
16 December.
then
But then
next
they
of-
are not appearing. Is it proper to fix?
My lord, I have the copies.
Okay, okay. Then as prayed for by the land council for the petition, list this matter again on 16
December.
December.
My lord, there's an interim order.
The interim, stop, para. The interim order passed earlier shall continue till the next. month. Okay.
Right. Deep here.
Yes.
May I please, Lordship? Lordship, in this case, I'm appearing on behalf of respondent number. Lordship,
In 18,
yes,
18 for respondent number
two.
2.
Lordship, in connection with IA number 7324.
Yes.
On the last date only, I have been served with a copy, so I'll be filing reply.
This is for IA is for what?
IA is under section 5 of limitation. Act.
Condemnation.
Yes. Well,
But you have objection?
yes.
How many days?
Yes, I'm the petitioner.
Delay of how many days?
565.
565 days.
So you have objection?
Yes, I'll be filing.
Criminal revision matter.
Okay.
Yeah, if they have objection, your lordship may kindly entertain because
No, no. Then let them file with.
Yes.
Okay.
And one more, this is a there is a connected matter. One more, this case is item number 19.
Just a minute. Mr. T. Tapa. Mr. Okay. Mr. You are appearing for the first time?
No,
Second time. I
Okay,
think
Mr. T. Tapa. Learned counsel appearing on behalf of the respondent number 2, phrase for further 2 weeks time to file objection. The prayer is allowed. This is matter after 2 weeks.
2 weeks.
Okay, stop. And his presence also. Okay.
there is another matter.
Just a minute. That is 18.
Item number 19.
So in 19,
In 19, I have filed this petition of interim order. Because
Mr.
trial is
Mr. Tita, you are appearing in
On
item
behalf of
19 also.
petitioner. Yes, in item number 90. It's a connected case.
Same arising out of same case, same project.
Okay.
So what do we do? Yeah.
This matter may be fixed for argument along with the same case.
Okay.
With item number 18.
main proceeding has already been stayed in
Yes.
item number 19.
In 19.
Yes, your lordship. Proceeding has been stayed.
criminal proceeding against the accused has been already stayed by this honorable court. So
There is order in this 19,
Yes,
item 19.
yeah, that is on 12/3/2024.
Criminal petition 31.
Yes, 12/3/24.
Criminal petition 10. What is this 10 again?
In criminal petition 31/24.
31, okay.
Yes, order dated 12/3/24.
Okay. Heard Mr. Tita, the Islamic counsel for the petitioner. Also heard Mr. Tapa. Tapa, you are for respondent number here,
Yes,
item 19,
respondent here.
and then here,
And I have,
18, for respondent number.
Respondent.
Okay, for respondent number, you are representing. Mr. Ete will represent one state respondent, for the state respondent, and Mr. Tapa for respondent number. Two.
It must be 2.
Okay.
I am for 1.
2. To reflect that Vakalatnama notice, you have filed already Vakalatnama?
Yes.
Okay.
I have filed one
IA also.
interlocutory application for
Yeah.
petition of the interim order.
Okay.
Because there is an inordinate delay in disposing the matter.
Is great. This is matter along with. It is along with the petition
For
only.
final disposal
This is matter on.
on the same day.
Okay.
Since the matter is connected matter.
Okay. Along with the item number 18, huh?
Then the party to file
Right.
objection.
So there is a stay,
Yes.
interim here.
Interim may be continued.
The interim order passed earlier shall continue till the next day. Okay. 2 weeks. Oh,
Day privilege.
yes.
May I please, Lordship?
Yes.
Lordship, conducting counsel for the petitioner, Mr. O Modi, have some personal
Okay.
difficulties.
Mr. You are Mr.
N. Nobang.
Okay. That the conducting counsel, Mr. O Modi, he where he is?
He's some personal
Okay,
difficulties.
he has some difficulties today, hence pray for adjournment. The prayer is allowed. This matter after 3 weeks.
1 week.
After a week, okay. And then it is present may be recorded. Yes.
My lord,
Yes.
this is an application where I have filed my application under 42, rated 439(2) of CLPC for setting aside a bail order which was passed. My specific allegation was that particular parameters of the judgment of the Honorable Supreme Court was not complied with while passing the order. There was a whole sole ground.
Cancellation of bail.
On perversity, my lord. Because there was no specific reason for granting the bail, then my lord will find in page 15 of my application. No reason has been said as that because it's a very heinous crime, 302. It's a case of 302, my lord. Page 15, my lord. If the lordship permits me. Just on the ground that he spent 1 year and 2 months in the judicial lockup since his arrest. And he was 70 years old. Then, my lord, there's a statement, the deposition of the witnesses, the 3 witnesses, they have given 164 statements.
The case is on the trial now.
The case is on trial now, my lord.
On trial.
And
How many evidence has been recorded?
how many 5 witnesses have been examined?
How many total witnesses are there? Prosecution witnesses?
What's the bench? Altogether 19 witnesses, 20.
20.
My lord.
Out of 25 witnesses
5.
recorded. Okay. Now the bail was granted by the district judge, session judge.
Session judge.
Session judge. On what ground?
The ground that the accused spent 1 year
Okay.
and 2 months.
Okay. Then what is the ground for rejection? Cancellation?
The ground for cancellation, my lord, that is on, because when it's a case of heinous crime 302, my lord. So the PW number 1 and 3 have clearly stated that they have given their 164 statement before the magistrate.
Okay. There is a prima facie case
My lord.
against him. So according to you, he is likely to be convicted.
Likely.
But what is the ground for cancellation of the bail granted by the session judge?
My lord.
Have you, whether he has violated any bail condition?
Yes, the parameters, the acquisition, and in the event of conviction, how much he has to spend. The heinous nature of the crime was never taken into account, my lord. The heinous nature of the crime.
Now, you see, the bail is.
It's a matter of right,
Yes.
my lord. It's a matter of right.
Yes.
But now recently things has been changed, my lord, because
And it is discretion, at the discretion of.
it's a discretion of these.
So that is why, how do we interfere with, unless you so satisfy.
No,
the court?
that I'll satisfy, lordship, the
Yes.
perversity. My lord, if I respectfully take my lord to page 15 of my application, my lord.
Page
15, NHA A1.
bail order.
Bail order. This application has been filed under section 439 CRPC for granting bail to the accused Nami Chatung, who was arrested on so-and-so in 302 and 341 IC. So-and-so counsel for the submits that the accused has spent 1 year and 2 months in judicial lockup since his arrest. It is submitted that the antecedent of accused is clean except being implicated in the present case. Mr. Travin contends that since the beginning of the accused has fully cooperated with his, and he is doing the
Since the beginning of the investigation, accused
No.
is, okay, fully
No.
cooperated,
No.
okay.
Mr. Likatavin, counsel for has relied on the judgment so-and-so. R. Buddha, learned PP, and Mr. T. Tado, counsel for the complainant, strongly opposed granting bail to citing the accused being a retired police constable has shown his influence in past. As there is a chance of him threatening witnesses, those who are yet to be examined. Learned PP, Mr. Buddha submits that one eyewitness of offense is yet to be examined, and he being none unnaturally, the accused may intimidate or coerce him so as to depose or give evidence favorable to the upon hearing the learned counsels.
Any instances of threatening or the Interpretation.
There was a submission there before the trial court by the learned PP as well as by the.
No, that is only
that-
submission.
That is submission.
Now, what I'm saying, my query is whether after obtaining bail, after his release, whether any instances of threatening
That
or intimidation.
has not come. It has not come on record. So for this record is concerned.
Okay.
Now, upon hearing the learned counsel and facts, I have thoroughly perused the records. Till 14/6, prosecution has examined 3 witnesses. 2 are stated to be family relative of the accused. I have also seen a civil report which indicated that the blood still found in the weapon was of human being, blood group of any person not disclosed in the report. Investigation has listed 27 prosecution
Not
witnesses.
disclosed.
Investigation officer has listed 27 prosecution witnesses and only 3 have been examined so far as presiding officer was on medical leave for last 6 months. Apart from the above, it is found that the family members of the deceased are continuously protesting with slogans, Nami Chatungo Fasido and Bardo since the beginning of hearing in this case. The protester family members and victims have statutory right to demonstrate, etc. However, they have been strictly directed by the district so and so to stay dharna or demonstrate beyond 100 meters radius from this court. They have been sloganing, showing placards and shouting at the president, just standing at the gate of the court today, as well as 3 previous occasions demanding justice for the victim. This is a bad practice trying to influence the court into outcome of the case, including the stand matter. I've seen the executive order issued by the learned district magistrate so and so, and the producers are disobeying and violating the said order. The OC Police 0 is directed to register and so. Later on, one Mr. Tado, counsel appearing for the victim, prayed for expunging sentence of lodging FIR from the records. Prayer is allowed, however, the demonstrators are forced to obey. The evidence collected by the investigator and ocular evidence as well as documented evidence so that the victim died as homicide. I have also given due consideration to the grounds pleaded by the accused, and he is stated to be 17 years of age, having permanent residence at home. This is what the reasoning is given in a heinous crime.
Please.
This is the only reason given in the heinous crime of 302. And my lord,
Now, see, this is, you see, he has given some ground on merit also.
no, what has to be given?
Exercise
No, no.
the discretionary power.
No, the discretion power has been now at its curve by the Supreme Court in a recent judgment, even in 2024. Because in granting or in denial of bail, my lord, recently, even in 2024, the Supreme Court has come, the nature of the crime has to be very relevant. That has to be the key consideration. That starts from
At the most, what we can do is the trial can be expedited.
No, question is, my lord.
If you
My lord,
say so.
my lord, the question is whether the session court has taken the parameters or whether it has followed the catena of judgment as laid down by the Supreme Court, the principle while granting bail in case of 302. And if the conditions are fulfilled, my lord, if the conditions are fulfilled, the discussion comes. So it has come down from Ram Govind Udhabat, my lord, how case of 302 has to be considered. My lord, till now, there's a positive time also, my lord, if your lordship permits, I can continue at 2 tomorrow. Because I can continue at 2 tomorrow. I'll stay back and continue at 2. Because I have to cite at least 7, 8 judgments. Because there are a lot of judgments, so my learned friend will also cite. Because this is a case of very exceptional, my lord. Now it is the nature and of giving bail, my lord, in case of heinous crime, has been covered by the Supreme Court. Because that has been very strictly, in a very interpreted in a very different manner, my lord. Earlier, the occasion was a discretionary power of the court. But since it has been granted in 302, and my lord will find in one cases where justice
Basically, what are these conditions
my lord,
to be fulfilled? Because discretion, it can't.
Discretion,
difficult to measure
my
mathematically.
lord, I'll just read out one because I have got. For grant of denial bail, the nature of crime has huge relevancy. The key considerations which govern the grant of bail were elucidated in the judgment of this. Number 1, apart from the above, certain other which may be attributed to the relevant consideration may also be noticed at this juncture, though, however, the same are only illustrated, not exhaustive. Neither there can be any the consideration being, while granting bail, the court has to keep in mind not only the nature of the accusation, but the severity of the punishment. Now, the question is, Why I'm coming to the severity of the punishment, my lord? Out of these 5 witnesses that have been examined, my lord, 3 witnesses out of these 5 have given their 164 statement before the magistrate. Before the magistrate, where
Implicated.
they have given implicating the accused, because the accused has told to them that he's the one who has killed the Nani Chatum. And the 2 are sister and son. And they have given their deposition on oath after 1/6, and they have affirmed that it is their signature and it is statement given by them. Now, if
Whether the record was called for,
my lord, record was called for,
scan copy or the original?
scan copy of the
Scan
record.
copy. Now you see, the Lanek court below has also appreciated while passing the
Now-
order, on fact, on merit of the case also, blood group of any person not disclosed in the report.
No, I'll come.
All those
I'll
things are
come-
also there. Then
Because,
how do we measure?
no, I'll come to that, because the knife which was sent for the official, within certain questioning was sent to find out even the blood group. The blood group was not answered. The blood group was answered only in a very casual manner. It has been said that it is in a,
Just a minute, now, this was filed, when this was filed,
this part.
when this record was received, till the receipt of the record, how many witnesses were
Two.
examined?
Two.
Only 2? Now we need, I think, the present record also. If you are saying so,
The deposition of this recently, 2 witnesses is with me, the certified copies with me. Even my learned friend will have.
But the 28 certain witness was also examined. 23, yeah. So altogether, 6
Six or 6,
Six
I'm
witnesses.
sorry, 6
6
witnesses.
already
examined.
examined.
Yes.
So now, if you are, because the Dharmic court has also made an observation on merit of the case also, saying so. And then if this has been contradicted, I mean.
Now, I'll come to that part also. ma'am.
So,
If your lordship permits me, I can continue tomorrow. I'll stay back. And I can continue at 2, my lord.
but today, at any course, the time, we have a paucity of time.
Yeah, because of possible, I understand paucity of time.
Then
And it will be, because my learned friend also will argue, and I have to also argue a lot of
That's
things.
right.
So if your lordship kindly, I'll just, if your lordship permits me, either tomorrow or on 7th or on 14th.
What do we do with the other records? Only 2 we have with us.
We are.
The position of only 2.
Yes, yes.
Prosecution with
Yes.
Mary.
What three? Earlier it was limited manner. Now
3 has come, 3 I have obtained a certified copy. Your lordship, there's a certified.
Can we base on that?
Yes, certified copy, my lord. Certified copy.
should be based on the record.
No,
Have to
but
be,
that is certified
scan
copy.
scan copy from the.
In that case, if your lordship permits me, getting the scan copy, then I can continue my argument on 14, because
We'll do that.
on 14,
What do we say?
but on.
What do you say?
Your lordship, here, in my humble understanding, your lordship, there is no any requirement of calling for the record. Why I am saying so, your lordship? In 2 aspects, the bail can be cancelled. One is for setting aside, and other is cancellation. Cancellation comes when condition is violated, and setting aside is when the order contain perversity, when certain principle of law is not being complied with by considering the bail. Now they are on setting aside of the order, not for cancellation of bail. Yes. So now from the order itself, your lordship.
Then we'll have to examine the order itself.
Yes, your lordship. There is no any requirement to go see the updated case, the updated one, the status, whether to what extent the this witness proceeding has been, your lordship, developed, or to what extent the witness has been examined. That is not required. Whether while passing the order, the relevant principle was complied by this learned court below or not, trial court or not, while granting the bail. That has to be looked into. That much only. This is the limited aspect this court has to consider, your lordship.
So, what are the authority you are basing on?
No.
Authority you are basing on, besides this one?
My lord, I am placing about 7, 8 authorities.
Okay, 7, 8.
So I have to interpret that also, because the Supreme Court has heavily came down in all days. My lord, Supreme Court has heavily come down while granting bail. It has even gone to the extent of grant of bail through discretionary nature, yet such as cannot be arbitrary. It has come to that extent also in the recent judgment. Because it cannot be arbitrary, capricious, and injudicious. Heinous nature of crime warrants more caution. So that caution of the heinous crime, of the heinous nature of a crime, was not taken into consideration. The consideration that was taken in was that he was 70 years old. My lord, therefore, I have to interpret, my lord, the liberty of an individual, what your lordship has said, the liberty of an individual is not absolute, my lord. Society, by its collective wisdom, through process of law, can withdraw liberty that it has sanctioned to an individual when it becomes a danger to the collective and to the social order. Because how the crime was committed, how the crime was committed, and in the follow-up of that, how it was revealed to his sisters, and how his sister is given the 161 statement. There's a CCTV footage of the 161 statement, and even there's a CCTV footage.
That is on merit.
That's on merit. Therefore, on merit. But however, without considering that, the learned session court has only gone to the extent that even the knife is of human blood, but the blood group cannot be established. He has just cited one merit of that, and taking into consideration his 70 years, he has been released on bail. So I have to come because the judgment has to be interpreted, because there are series of judgment which now it is in our favor, because the nature of the crime, the heinous nature of the crime, which warrants more caution, has not been exercised with all my respect by the session judge. So your lordship may kindly fix either on 14, or if your lordship
Fix on 14? Yes, your lordship.
Can it be because
14 afternoon?
Whether I will be praying too much, if it can be fixed at 2.
Okay.
At 2, soft. 14,
Okay.
at 2.
The last item.
At
We'll-
2.
we'll say it's last item.
At 2, but this is every time whenever I go, it's the last item. So I don't get a chance to argue. But if it is fixed at 2, at least I can put my argument. 14.
Learned counsel for the respective parties are present. Due to paucity of time, the matter could not be heard. So accordingly, the party prays for the matter to be fixed on 14 at 2 p.m. Prayer is allowed. List this matter on 14 according.
Deeply obliged.
Obliged, my lord.
Finish.